I double dog dare you.
Ma'am, you can't sue the baby.
This case is horrible.
The promiscuous defecation kind of speaks for itself.
Hey everyone, and welcome to part 2 of your 24-hour non-stop, but no, I guess it does stop because it carries over to the next day because I can't do 24 hours non-stop. Okay, let's start over again. Hey everyone, and welcome to part 2 of your stopping, but continuing marathon, but in parts. Yeah, none of that made any sense. Okay, this is part 2. We're going to watch some of our favorite court hearings, most of which have never been seen before because they were dusty deep inside the Meg's Crime Watch vault. I hope you all had a wonderful holiday. If you haven't seen part 1, there is a link in the description. The pups and I are working on recovering from our fun little bout of everything wrong. And we got some fun ones for you, so let's just go to court. Oh, and P.S., I watched a lot of these videos, parts of them, but I didn't watch the entire thing, so there may be some sensitive information that got left in. If you see any of that, please go to the comment section at the very top. There should be a pinned comment. Please reply to that comment to make sure I get a notification so that I can go in and edit it out. Please include a timestamp so I know where I'm going. I really would appreciate that, and I will get it out of there ASAP. Thank you, and let's go.
I don't know what the real story is here, folks. I don't appreciate it.
But does it really matter?
If no good deed goes unpunished.
You're going to make me send you to jail.
Good morning, Your Honor. Happy holidays.
Happy holidays to you. We are here on cause number FM 23-003821 in the matter of the marriage of Von Backstrom. Go ahead with your appearances.
Your Honor, as the petitioner in the divorce, my name is David Minton, and I represent Mr. George Von Backstrom.
My name is Kelly Osley Flores, and myself, along with Angie Comier, we represent April Van Backstrom.
Okay.
Your Honor, as a preliminary matter, you've given us an hour. How did you intend to divide that time?
Why don't you, is there anything set besides the motion to modify, correct, or reconsider?
No, Your Honor, not that I'm aware of. I do want the court to be mindful of some of my legal eagles have looked at all the time factors and that sort of thing, and pursuant to the Texas rules of civil procedure, I think that we're supposed to have a ruling by 75 days after the judgment is signed, which falls on this coming Sunday. So potentially it is Monday. We filed lots of different things, but the consensus, at least in this firm, is that that probably is still a hard date. So we tried to keep this to a very simple request with the court, and I'm ready to proceed with a very brief opening if the court is ready.
That is fine. You're the movant, so you may proceed.
Thank you, Your Honor. As the court noted, we are here on a motion to modify, correct, reconsider, or reform the judgment that the court has entered in this case. And one of the things that has been sort of a difficult situation for me is when a person has lost a job, as was previously testified to, or the job was completed at the end of March of this year. That was a job that paid Mr. Von Backstrom $8,000 a month. John Mankin testified that that was a house that was being built. It was finished, and one of the exhibits that we are going to talk to today is the exhibit that was placed in evidence by both Ms. Osley Flores, which was a proposed support decision by my client in January. There was a previous setting for this case that had the amount of $8,000 in there, plus some additional funds that were later turned over in the court's ruling. There was about $700 a month from an entity. And so those were the resources at that time. This court then admitted into evidence, and we'll see it, I believe our Exhibit 38, indicating that at the time of the trial, he was making approximately $3,000 a month in doing odd jobs. We'll get into that in more detail, but very briefly, the conundrum that I have is, what should a person prioritize in the way of money that is owed? Whether that's child support, whether that is spousal maintenance, whether that is a mortgage, whether that is utility bill, what is the priority? And it's important here because if child support or spousal maintenance is not paid, then my client faces an enforcement mechanism, which can include contempt and possible incarceration. As this court is aware, in this final decree, there was one real asset left, and that is the marital residence. My client is in charge of that marital residence in maintaining it, repairing it, paying the mortgage on it, keeping the electricity on and the propane on, and those sorts of things. We are going to demonstrate without a doubt that with the money that he's earned doing odd jobs in the construction industry, that just those 5 or 6 things, excluding food and clothing and anything else other than the school that he is required to pay for this year ending in May of 25, is almost double what his income is. And Mr. Von Backstrom will go through and walk you through all of the money he's made, how he's made it, and what he has been doing in trying to find and get back into a job that pays enough money to pay whatever this court orders in the way of support or maintenance, and in order to get that house sold. And my first questions to my client here shortly are going to be, what is the status of the sale? That's all I have, Your Honor.
All right, Ms. Osley Flores.
Judge, I'll be responding on this matter. Judge, this sounds like Mr. Von Backstrom is attempting to take another bite at the apple. This hearing appears to be more than a motion to modify, correct, reform, or reconsider the judgment. It appears to be more like a motion to modify child support. And I'd like to just briefly procedurally walk the court through what has happened in this case since the judgment.
Your audio just went out. It's very low.
Can you hear me now?
No, not really.
Okay.
I don't know. The volume just dropped.
Can you hear me now?
It's a little bit better. I think
Microphones.
want to make sure there's nothing blocking your microphone on your computer, or just.
I don't think so. How about now?
That's much better.
Okay.
Thank
Okay. So, Mr. Von Backstrom, in July, this case was heard in early July. On July 30th, he filed a motion to clarify. On August 26th, he filed requests for findings in child support. The decree was entered on October 8th of 2024. And then after that, he requested findings of fact and conclusions of law. Well, the court entered findings for the child support order, and those findings were very clear in determining whether it was appropriate to apply guidelines or not. The court found that it would be unjust or inappropriate to apply guidelines, and considered 6 different factors in applying 6 different factors when determining the amount that Mr. Von Backstrom pay. Now, following the findings in child support for the child support order, Mr. Von Backstrom and his original findings of fact, request for findings of fact and conclusions of law, only requested findings of fact and conclusions of law with respect to the property division. He then sought to, after those findings of fact were entered, to have the court amend or he asked for additional findings of fact, which was denied. So there's been multiple attempts by Mr. Von Backstrom to take another bite at this apple. In neither the period of time where the decree was entered, and I'm sure the court remembers we had a full-blown litigated motion to enter hearing, and then there was subsequent issues. Was there a change to the, I'm sorry, there was never a change to the child support language in the decree reflecting that this was going to be guideline child support. And then subsequent to that, when we were discussing the findings in child support, Mr. Von Backstrom never entered a competing finding. So we are here today on a motion to modify, correct, reconsider, or reform the judgment. And this isn't an evidentiary hearing. This is a hearing to determine whether or not there's an indisputable error in the judgment, whether or not the court misapplied the law at the time or new law has been entered since the time of the judgment, which is not the case, or whether or not this is so unjust to Mr. Von Backstrom that the court abused its discretion by ordering whatever child support amounts or whatever spousal maintenance amounts were ordered in that previous order. This is not an evidentiary hearing, and I think that they're attempting to reopen the evidence and have another full-blown hearing on this issue. We strongly object to reopening the evidence. The evidence was closed. The court made its ruling. I understand that they're doing this to preserve their ability to appeal. I mean, if we're talking about where the parties are, the parties, both of them, had a ton of debt. The attorneys are owed thousands and thousands of dollars, and we've been going at this since July, and it's December. I just want to correct one thing that Mr. Minton stated. The parties don't have a mortgage per se on the house. They have a pool loan, and I believe that's what he was referencing when he was talking about the mortgage. So, Judge, for those reasons, because this isn't a reopening of the evidence, this isn't a this is a very specific hearing. So for those reasons, we object to reopening the evidence. We object to additional evidence, and we think that the findings that the court made with respect to both the property division and child support are in the record and support the evidence that was heard at trial and the court's judgment.
All right, Mr. Minton.
Yes, a very briefly response, Your Honor, to that is that I absolutely have the right to file what I have filed. I think that I will point out, and I mean no disrespect to this court, in fact, with the evidence that was before the court at the hearing and the proposed support decision upon which the court's ruling regarding the spousal maintenance and child support are not supported by the evidence. The evidence at trial was my client was working odd jobs. He had prepared Exhibit 38 that was entered into evidence at that hearing that showed that he had $3,000 a month in earnings through odd jobs. And if you do the child support calculation on that, then you would have a child support number of $452 and some pennies. And we are asking the court to modify that to what was actually put into evidence. And also, if you were to look at the spousal maintenance award, of $2,150, when you have $3,000 in gross earnings at the time of the trial, then the calculation of 20% would be $600 per month. And we are asking the court to make those two corrections to the award of child support and to the award of spousal maintenance. And again, when you do that math, I go back to my opening remark. What do you prioritize when you owe in the way of debts much, much more than that? And what's the priority? What is paid first? And while this is a pool loan or a mortgage, there is a lien on the property. If that $131,000 isn't paid, it's foreclosed on. So my client will testify as to the priorities that he's made. And because there is not the money by any stretch of the imagination, then the mathematics that the court utilized with the evidence at the time, because keep in mind, what you used was the $8,000 per month. That was what we had filed as a proposed support decision in January. His job was completed in March, and that $8,000 a month was gone. And even at $8,000 a month in gross income, Judge, it would only be $1,600 if he was making that kind of money at the time. So the court did err in the mathematics of formulating the child support award based upon the uncontroverted evidence what my client was making.
May I respond, Your Honor?
Briefly.
My brief response, Your Honor, is I can go into a lot of factual. I know this case very well. My client, she owes us $58,000. Mr. Van Backstrom had separate property. The house is currently listed, and people do not have resources until the house sells. I think things will change once the house sells, but I do not believe that we can reopen the evidence, because then Ms. Van Backstrom would also need to testify about what is existing today. We would have to reopen all of the evidence, and I believe there is no rule of law to reopen evidence. We can, Mr. Minton and I, we can argue back and forth about the facts for probably an hour. It's not going to change anything. I think your ruling is clear. I think the findings of fact and conclusion of law is very clear, and that could have been amended. It was not. So we're asking that you deny the motion. And if they choose to do something further, then they will choose to do something further.
To that one point, Your Honor, I 100% agree. If this court were going to, and I believe the court has the power to correct or reform, let's assume that it does not, which I hope that that's not your position, Your Honor. But the idea that when this house sells, clearly the court could potentially enjoin enforcement until such time as that house sells, and out of his portion can pay the money. Right now, he's looking at an enforcement action that has been filed by the AG's office because he cannot pay the support and the other 4 or 5 very important items. So it's a conundrum that I don't think this court has seen very often, and I darn sure have not. But there is no money, and there wasn't at the time of the court's ruling. So whatever it is that you do, if we are not faced with enforcement, I'm owed $80,000. If we don't have to deal with that, of course, if the court puts the man in jail, then there is no money whatsoever. But Ms. Ausley-Flores is 100% correct. This changes everything. Both parties are going to walk away with least Miss Von Backstrom roughly $300,000. If the house sells at what we stipulated the value is, there have been no offers yet. And that when that's done, we can catch up whatever the court feels like was right. I will point out to their argument, mathematical mistakes made by the court. And again, Your Honor, I mean no offense to that, but those are the numbers that were presented to the court as to what he was making and what his bills were. And yes, there is a lot of credit card debt. My client's maxed out, and I assume Ms. Von Backstrom is maxed out. But I can turn quickly to the two exhibits that they put in regarding Mr. Von Backstrom's and go back to the testimony about when he lost that job, and it's that clear.
Okay. All right.
I would like to respond to that, Your Honor.
Okay. That's fine. Go ahead.
The evidence is not just the proposed support decisions by both sides. The evidence was a day and a half of testimony involving many other things, including factors that a court can consider on child support and spousal maintenance. The one thing that both lawyers can agree on is that we're owed thousands and thousands of dollars. The other thing that both parties can agree on is that there are no funds at this very moment to pay certain bills. Now, Mr. Van Backstrom, I have no insight into his income since July 1. Don't want insight. The same is true for April Van Backstrom. We have no insight on her income from July 1st forward. The evidence was closed. There is no more argument about what was done. There was a day and a half of testimony about what income was, what each party had access to, and there was back and forth about all of these issues. And so I am arguing that this evidence has been closed. There is a ruling, there is findings of facts and conclusions of law, and they've been signed. And to reopen this, I'm urging you to deny their motion.
Again, when you're looking to correct, which this court has the ability here to do, and if I could, Your Honor, I could demonstrate exactly what I'm talking about from the standpoint of a proposed support decision that he filed where he had a job and was making $8,000 a month. I have a tax return to show what he made in the previous year, which is $96,000, which is 8,000 times 12. And what we presented after that job was lost, and the uncontroverted testimony was that his job at $8,000 a month concluded March 31st of 2024. That is in the record. It is uncontroverted. And not only did he testify to that, his partner testified the house was completed and I'm not building another house. So that's the evidence the court heard on that day and a half, and then made calculations based upon what they put in their proposed disposition of issues. But the exhibits, and if the court,
I have to argue back, Your Honor. Private school tuition came up. These parties have the ability today to take that child out of private school. Private school tuition is not being paid. That child very well may need to be in public school. You talked about it. There are other factors other than just what he's talking about. There are additional factors. Mr. Van Backstrom has the authority to not have his child in private school. That is agreed to.
no, that's a mistake. He was ordered to pay for the 24-25 school year. He has the ability in May. The testimony of both parties was stability for this young man was clearly very important. Changing him midstream was not something either one agreed was in that child's best interest. That's the testimony this court heard in the day and a half you're referring to, Ms. August Flores. Undisputed. One of the few points in which they agreed upon. Let's don't move that kid now. What we asked the court to do back then was, if we pay that, then we shouldn't be paying child support at all. And the court denied that in her discretion. But he's only not paid the last 3 months. And there will be a reason potentially for that he's working with him about potentially building another school. But he owes the money. It's a contract. So I think you got your facts a little bit wrong about what actually was in evidence at the day and a half hearing.
Okay, well, I recall the parties agreed to the private school, in spite of the fact that it's not a decision that seems to make a lot of sense given their overall financial situation. But that's a decision they made. It was not it was a decision brought to the court, in other words, by the parties' agreement.
And that's accurate, Your Honor, but only for that 1 year. I think the court remembers that if he gives notice, he could pull him out in May.
Okay. So I just want to refocus us and make sure we're all on the same page in that we're here only on the motion to modify, correct, or reconsider. And I believe the judgment will either be supported by the record or not. And I do credit the arguments again that we don't need new testimony here today. We're not here on an enforcement. I don't see an enforcement in the file. I don't think one is set or noticed for today, at least. Am I correct on that?
Your Honor, we've been just given notice of the AG's office, so we know that that's potentially coming. We set up the account. There's arrearages of about 16,000. And so we know that's coming, but one of the things we're going to be asking for is the court to reform the amount of the child support and the spousal support to what mathematically was in evidence. And if it does that, then, that reduces the arrearage. He has paid her $1,500 in child support. But there would be a clear from that amount of money. And then, of course, and again, I hate saying these words, Your Honor, but the math's just simply wrong with what the court did here. If the court says, I don't want any new stuff, then let's just go back and let me walk you through the math that was in evidence, uncontroverted.
Now, I disagree, Your Honor. What I would say to you is
They don't want to go there, Judge, because I'm right.
No, I don't agree with that. What I would say to you is there is no motion for enforcement on file today. I know our office is absolutely not filed one. And the AG, they're talking about this man's going to be incarcerated. That is an exaggeration, and we know it.
Of course, but it is a possibility. It goes to the decision making that has got to come into play, that has a community property interest that's ordered to be sold, in which all of these problems go away. If this court were to sit here and say, could you people agree as to whatever number I'm going to change or not change, that's due out of his portion of that sale, we don't need to be here.
First of all, you've never approached me with that. And so I haven't even talked to my client about it.
Can we go briefly to the two exhibits that this court that was in evidence on the day of the hearing, Your Honor?
Gonna object.
Are these?
It's not new evidence. It's the same evidence that was in.
But I have lots of evidence that I can open back up and for her to review. You want to pick out 2 pieces of evidence in a day and a half of trial. I object.
I get that, but one you put into evidence and the other I did.
Mr. Minton, are they attached to your motion?
Your Honor, they are in the exhibit list. They are number 4 and 5. 4 was trial exhibit R, meaning Miss Von Backstrom, 02, which was George's proposed support decision from January 22nd, 24, which before this case was continued. The trial exhibit number 5 is petitioner's 38 that was admitted into evidence, which is George's proposed support decision of June 17th, 2 weeks before the trial. And I don't think the court needs the refreshing that John Mangrum testified and my client testified he did not any longer have that $8,000 a month job. I didn't put that in because I think that's clear. That is in my motion to modify, correct, and reconsider, where I have noted the testimony of Mr. Mangrum. So, but if you look at those first 2 exhibits, you will see the conundrum that I'm in. And maybe this court take us off in chambers and say, what about holding off on enforcement with the potential of incarceration? I didn't say he would be. I doubt that he would. But I think the court could suggest to the parties that's a good idea.
Your Honor, my only argument.
That what is a good idea, Mr. Minton?
That whatever it is that you decide, if you decide not to correct or reform anything, I believe there's a math error. I really do. But if you decline to do that, then am I faced with tomorrow or Monday an enforcement when we are doing everything we can do to get that house sold? Because that makes everything go away. And that's what's so difficult about this. There's no money to pay this, to pay income taxes, to pay property taxes, the other stuff on this particular residence that's for sale in a market that is horrible in Austin, Texas. And I know that this court has heard from many, many experts and other folks about that situation. This real estate agent was one selected by Ms. Von Backstrom, and I think is working her tail off. But we've had 4 showings and no offers.
I'm going to object, Your Honor. And the reason I'm going to object, this is not the time this is not where you do that. There is no motion for enforcement on file, and you don't bring it up at this hearing. I'm going to object to what he's asking about. There is a lot of other credible evidence other than 2 exhibits. And he and we could argue till noon on Mr. Minton and I, we could argue to 12 noon on this very issue because there's other credible evidence in the record about what the ability to pay. You have the authority to go beyond guidelines if you see their ability to pay.
But I don't
The
have to.
house not,
George?
the house not selling is a concern, but this is not the time to address an enforcement and that Mr. Van Backstrom will pay in full what's past due at the time of closing. That is not this hearing. That is a different hearing. That's when there is an enforcement on file. There is not one on file.
Oh.
All right. Mr. Minton, let me ask you this.
Yes, ma'am.
I've got the exhibits written down that are part of the trial record that you want the court to go back and review before I determine this motion. I've got that. I'm going to do that. I will take the time to do that probably later today, Monday at the latest.
So you've already finished your Christmas shopping?
Yes, I have.
I haven't.
And so I'm going to do that. And I think you've told me why you think those exhibits mean that the judgment is wrong or should be modified, should be corrected. Is there anything else you need to tell me?
What I would have done today, Your Honor, in the way of testimony, because I think it's important for the court to have some understanding of he lost his job and what he's been doing, because there could be, at least in the court's mind, was he getting drunk at night and getting out of bed at noon and not doing anything? The testimony would be is that he has gone to many job interviews in the industry of construction, which is nearly dormant here in Austin, and that he has done the stuff that he can do in order to take on work, which is essentially as a handyman. And because if and when there ever is an enforcement or not, I think a court would be rightfully concerned about what has the man been doing to try to make money, as opposed, and not just make money, but there would be evidence that he's sold items of his personal property, which you don't have to do to pay child support or any of your other obligations. Both of his automobiles are for sale and have been for months. And so I was prepared to put on that evidence to allay the court's concern that I've got a deadbeat dad and a deadbeat ex-husband. But if the court is disinclined to hear any part of that, but the exhibits I have is to show how much money he's made since April 1st, roughly $18,000, and that's it. And maxed out his credit cards, used up the rest of his separate property money, and still has the property taxes on that property, which gives him heartburn. If this thing remains unsold, is the county going to step in? Irrespective of an enforcement on this other stuff, does it create an issue as to that? And that's, I don't know the exact number, but I think it's like $9,000, $8,900 or something like that in property tax that's due the end of this month and late if it's not paid by the 31st day of January. Actually, it's due January 31. But this isn't an easy case. It's just not. And I'm not suggesting that Ms. Audley is not making the arguments that she should. But if the court looks at just those two exhibits, court's going to wonder why they put into evidence a proposed support decision that was accurate at the time. And if the court then looks at the other numbers that are important, the note on the house, which I call a mortgage, the electricity bills, the propane bills, and all that, just those 5 or 6 things, health insurance for just the boy and the school and other things, it is more money than he's making. And more money that was in evidence at the time, uncontroverted. There was no finding by this court that he was intentionally underemployed at the time of trial. Never has been.
Your Honor, I'm just going to object to any of his comments that talk about what has happened since July 1. And the reason I am is I know why he's making the argument, but all of the arguments that he just made has to do with enforceability and has to do if we were here on a motion for enforcement. There are many arguments that we have on the other side in regards to what was just shared, but we're not here for that. The parties owe property taxes. They're not due until the end of January. I guarantee you, Travis County is not going to foreclose on a home when it's listed for sale and they're not years behind on property taxes. And so any of those arguments I would object to because it doesn't have anything to do with today.
Okay. Well, your objections are noted for the record. Counsel, I think I understand where both of you are and how you look at the trial record and the judgment. And what I need to do is go through it one more time and study what has been put in front of me. And I will get you a decision by Monday at the latest.
Okay, thank you, Your Honor. Did you, I think I heard you, but I just want to be clear. In my exhibit list that I just uploaded, it's P004 and P005 are the two.
Okay, those are the exhibits you pointed me to that were a part of the trial record, but now.
Yes, ma'am. The P004 is their exhibit that they put into evidence that was a prior proposed support decision reflecting the $8,000 a month that he was making. And that was accurate at the time. I mean, they put that document in, but that's our document. That's what we filed with the court. And then the other one is the one that he filed just prior to the trial in early July. July 1, wasn't it, Ms. Lord? I think.
You filed it before we started trial on July 1, so I think it was sometime in June.
Yeah, no, it was June 17th.
Yeah,
is when we filed it.
And you're asking the court admit P4 and P5 for the purposes of.
Yes, Your Honor.
And I take it, is there an objection to those?
No.
Okay, then they are admitted into the record. Anything?
Well, Your Honor, I would like to put on what if the court is disinterested in what he's been doing to try to get work, then
I think she froze. I don't know if she's frozen on your end.
Yeah. Can you hear us, Your Honor?
Not sure what happened there. I'm hardwired, so shouldn't have lost internet. What did I miss? I think y'all were.
I was asking the court, you've entered those. Is the court sustaining their objection to anything about what he has been doing looking for work or how much he's made during that time?
Yes.
Okay, so I just need to be clear that the court is telling me I don't get any other evidence other than what was put into testimony at the trial.
I think that's right.
Okay, is that the ruling of the court?
Yes, that is. No evidence about what has happened between now and then.
Okay.
Okay. All right. Well.
Can I have a question? Can I ask a question, David?
I'm going to object, Your Honor.
May I have one moment to talk to my client and do this? A lot of stress going on here.
Do you want to call him on a cell phone, or do you want a breakout room?
I literally can walk across.
Okay.
And just give me 2 minutes, Your Honor.
Okay, let's do that real quick. We'll wait here.
I'm back, Your Honor. I think the question is not one that the court would entertain, but it was if anybody has any work for me to do, let me know. So.
And Your Honor, I just want to make sure for the record, it's clear that all of the evidence, including the two exhibits that you just admitted, that all of the evidence from trial can be considered by you in making this decision.
Of course.
Okay.
All right. That is noted for the record. You'll hear from me by Monday, okay? I hope y'all have a wonderful holiday. Thank you for your preparation, your professionalism. Best of luck for the new year for all.
Miss Oslet Flores and I can fuss and fuss and fuss, and then we can go have a drink and laugh and giggle. So just so you know, I don't take any offense to her remarks, and I hope she doesn't take any offense to mine. But have a happy holiday and a Merry Christmas to all. Be safe.
All right. Y'all take care. You're excused.
Thank you.
This is case number 224571601, the People versus Edward Lewis. Defendant is charged with weapons, I don't know what, and guns, reckless use. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people, and count one, Your Honor, is weapons, firearms, damage over $50.
Okay.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Lewis Edwards. Mr. Edwards, sir, please unmute and say your full name.
Lewis Aaron Edwards.
Today is the date set for pretrial conference. How are we proceeding?
Thank you, Your Honor. Mr. Edwards will continue his plea of not guilty. We would ask that this matter be set for final pretrial conference. We would request discovery.
The court continues a not guilty plea on behalf of Mr. Edwards and set the matter for a final pretrial conference, May 1st, 2024. Discovery should be submitted by April 2nd, I believe. No, April 1st. Bond will continue. Anything further?
Your Honor, it looks like the people sent discovery over on November 29th of 2023.
Why would you have done that?
Because there was an arraignment on the bench warrant on November 29th of 2023. And there's a pretrial set for today.
When I'm not here, I want y'all to please still set the things at the time that I normally set the thing. So if there's an arraignment on the bench warrant, he should have been at 8:25 or 8:29. Okay. So then the court will set up a final pretrial conference for April the 1st. Well, wait a minute. February, no, let's go with, April 1st. At 9:00 a.m. Anything further?
No, thank you, Judge.
Okay, no, nothing further on behalf of Mr. Edwards. Thank you, Your Honor. And I
don't see anybody sitting on my front row. I don't see anybody sitting on the front row. Nobody. Ms. Stevenson, what are you saying?
I do acknowledge receipt of discovery, Your Honor. I see it in there now.
Okay, then we're all set, Mr. Edwards. Have a great day. Stay safe.
You too.
This is case number 975882601. The People versus Lamont A. Leonard. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Mr. Lamont Leonard. Good morning, Mr. Leonard. Sir, please unmute and say your full name.
Hello, Lamont Emil Leonard.
Today is the date set for pretrial conference. How are we proceeding?
On behalf of Mr. Leonard, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Judge, it's the second scheduling of the pretrial conference. In this case, it's from 1997. The people tried to see if we could locate a complainant witness, which we could not. So at this time, Your Honor, the people will not be able to proceed.
All right, the court is going to grant defense counsel's motion. The people are unable to proceed. The complaining witness did not appear. Mr. Leonard, we will mail a copy of the order of dismissal for your record. Sir, have a great day and stay safe.
Thank you.
You're welcome.
Thank you, Your Honor.
Ms. Stevenson, are you ready on Barry or Lannis?
I'm ready on Barry. I'm not ready on Lannis.
Okay, can we bring Brittany Barry, please? I'm ready on Barry. This is case number 234567901. The People versus Brittany Michelle Barry. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Brittany Barry. Good morning, Ms. Barry. Ma'am, please say your full name.
Brittany Michelle Barry.
Today is the day set for pretrial conference. How are we proceeding?
On behalf of Ms. Berry, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter,
Your Honor, I don't see the complainant witness, Mr. Matthew Calloway, in the waiting room. However, it's scheduled as a first-time pretrial conference. Respectfully asking the court to adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
today is the day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I'm going to set the matter for Mr. Flanagan, how many do I have on March 4th, please? And does that include 8:30 pretrials?
Yes, Your Honor.
It's going to set the matter for March 4th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complainant could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Your Honor, I have a quick question. I believe the people indicated that they did not see Matthew Calloway present, and I just want to confirm the complaint shows the victim as Nicole Wright, that Mr. Calloway is the officer.
Ms. Ritter, who is the complaining witness?
It is Nicole Wright, Your Honor. My apologies.
Okay.
No
so
problem at all.
No contact with Nicole Wright. All right.
No.
Ms. Berry, we're all set then. Have a great day and stay safe.
Can Ms. Berry wait in the hallway for me, please, Ms. Berry, if that's okay?
Okay, go wait in the hallway for your lawyer. She's going to come out and speak with you.
Thank you.
You're welcome. All right, I'm going to go off screen anyway. Give me a five minutes and I'll be ready.
Thank you.
You're welcome. All right, I'm ready on Breck. This is case number 234536601, the People versus Ian Hamilton Breck. Defendant is charged with operating while visibly impaired. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. May it please the court. My name is Matt Savage and I represent Mr. Breck. Ian, unmute yourself.
Mr. Savage, your P number, please.
51264.
Thank you. Mr. Breck, please state your name.
Ian Breck, Your Honor.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
On behalf of the defense?
No, Your Honor.
With respect to sentencing, is there anything on behalf of the people?
Nothing on behalf of the people, Your Honor. Thank you.
On behalf of the defense?
Your Honor, Mr. Breck and I reviewed the recommendation by the probation department. We think it's fair. We're asking the court to adopt it.
Anything from your client? Would he like to make a statement on his own behalf?
Go ahead, Ian.
I just want to apologize to the people in the community. I'm sorry, Your Honor. I see what I did was wrong.
All right, the court is ready to impose sentence. I would do so in the following manner. Well, and let me just make an observation. So I did notice, well, according to the report, Mr. Breck, he wasn't charged. It appears to me that he wasn't charged originally with a second offense notice.
That is correct. It looks like the prior offense was outside of that 7-window conviction. That 7-year window conviction.
Okay.
Yes, I think it's way older than 7 years. I think it's a 2011.
It is.
Case.
But let me tell you what that says to me, though. That says to me that in 2011, whatever the probationary period and the jail time he served, it didn't take effect. It didn't take effect because I feel, and I don't know if they had him to view the consequences video. I don't know if they had him to participate or to view the victims impact panel, because I don't know that they do it in person anymore. I don't know what they had him do, but it seems to me like if a person was able to see those things and then still drink and drive again, are they really sorry? Do they really apologize? At what point did they realize that they were hurting the community? It seemed like if you have one, so if you have one, it seemed like during that one, you should realize the damage that you could do to destroy lives and kill people and maim people and injure people and hurt people. So when we come to the place that it's the second time, I don't know that I believe that the lesson was learned the first time. It clearly wasn't learned the first time. So nonetheless, there is a recommendation for a 15-month probationary period, and I am going to accept that recommendation for the 15-month probationary period. That places a final review date of April 1st, 2025. And then the court is going to set an interim review date, at which point Mr. Breck will not be eligible at that time for early discharge. But if he's on track, then we will set a date wherein he may be eligible for early discharge. So I'm going to set a review date for May the 2nd. Let me make sure. Yes, I'm going to set a review date for May 2nd. At 10:00 a.m. The terms of your probation are as follows. You shall not violate any criminal law of any governmental unit. That means no new cases. You must report to probation on a monthly basis. You must notify probation immediately of any change of your address, phone number, or employment status. You must pay the following fines, costs, and fees. Mandatory cost of $210, a $500 fine, no restitution, supervision fees for the 15-month at a rate of $35 per month is $525. Of course, that is going to be prorated if he gets discharged early. And the court imposes a $100 pre-sentence investigation and substance abuse evaluation fee. Mr. Breck will submit to your analysis at least twice a month. If he tests at the 36th District Court, then he has to pay $10 drug testing fee to the 36th District Court. So I'm going to add $150. If they assign him to test outside of 36th District Court, the $150 will be removed and he will have to pay the agency directly, the agency where he tests. So the total fines, costs, and fees, $1,485. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any form. You shall not drive without a valid driver's license. You must attend and complete the alcohol safety education levels 1 and 2. You must submit to random urinalysis, as I indicated, twice a month. You shall attend the victims impact panel, watch the consequences video. You shall, I'm not going to order outpatient treatment at this time, but I'm going to indicate if any positive tests, then you must enroll in outpatient treatment. You must pay any outstanding tickets that you have with 36th District Court. According to the report, you have a $170 balance. I don't know what it's for, but you need to find out. If you have any outstanding warrants, which according to the report, you do not, but you must not have any outstanding warrants. We are going to mail a copy of this order to the Stratford Road address, and probation will contact you at the phone number ending in 8386. Anything further?
No, thank you, Your Honor.
Thank you.
All right, then, Mr. Breck, we're all set. Sir, have a great day. Stay safe. Council, have a great day. Stay safe.
You do as well. Bye, Ms. Ritter.
Ms. White, I'm ready. Well, I should have brought your client in earlier and made sure that he was connected. So your client is connecting.
Okay.
Meantime, I will bring in Ms. Jackson. Maybe you could call your client, Ms. White. I don't know. Oh, there they are. They're connected. All right, I'm ready on Wilson. This is case number 23579. 8601, the people of the state of Michigan versus Jamar Arnell Wilson. The defendant is charged with 1 count of assault aggravated, and today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Rita White on behalf of Mr. Jamar Wilson, P number P63046.
Good morning, Ms. White. Mr. Wilson, unmute and state your name. Mr. Wilson, unmute and state your name.
Can you hear me?
State your name.
Jamar Wilson. Good morning, Your Honor.
Good morning. Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
Nothing on behalf of the people, Judge.
On behalf of the defense?
Nothing on behalf of defense. I did have a chance to go through the report with Mr. Wilson, and everything appears to be actually correct.
All right. And
Actually correct.
Ms. Ritter, anything with respect to sentencing on behalf of the people?
So, Judge, with respect to sentencing, there was a plea agreement for a recommendation from the people for a term of probation, 24 weeks of anger management, restitution for any out-of-pocket expenses or medical expenses that the victim incurred, no contact with the complaining witness, Mr. Anthony Halliburton, and then consent to HIDA. I'm asking the court to adopt the recommendation from the people. The probationary term that was recommended by probation was 24 months. I would leave that in the court's discretion as to the term. But the 24 weeks of anger management, the people feel that it is appropriate and necessary in this matter, Your Honor. And the victim's statement on page 4 indicates that probation spoke with the complaining witness about restitution for any medical copays. They haven't received any paperwork. And I also spoke with the complaining witness on the day that Mr. Wilson took the plea, and I did indicate that he would need to send over any medical bills that reflects any copays that he paid, and I haven't received any. So right now, the people are comfortable with the restitution being set at 0. Other than that, Judge, nothing further from the.
Oh, you're on mute, Judge. You're on mute, Judge. I didn't hear.
Oh, there we go. Okay.
Sorry.
I just said anything on behalf of the defense.
Yes, Your Honor. We would leave the term of probation recommended in the discretion of the court. Mr. Wilson, actually prior to and during and now, has already been engaged in mental health treatment. When I actually spoke with him initially, he was actually inpatient in a mental health facility. So I would ask that the treatment he is receiving, that be just part and parcel incorporated into his program instead of adding additional treatment protocols, mental health wise, to him. Other than that, I would ask that you adopt the recommendation to include HIDA. And other than that, again, we would ask that we would leave the discretion of the term in the discretion of the court.
Would Mr. Wilson like to make a statement on his own behalf?
No, Your Honor.
All right. Court has had an opportunity to review the pre-sentence report. I'm not quite ready to impose sentence in that I have requested the mental health treatment court to log on to the Zoom. So I'm waiting on them to log on, because here's the thing. In reviewing the pre-sentence report, the court noted that Mr. Wilson, so in my opinion, at this particular time, I do not particularly see Mr. Wilson as a good candidate for probation. Mr. Wilson has a probation violation hearing scheduled on a 2022 conviction out of the 52nd District Court. Mr. Wilson also had he has pled guilty in 39th District Court previously on a probation violation sentence. Twice he pled guilty to probation violation and was sentenced additional 3 months, additional 9 months. And then he also had 2 other probation violation in 52nd District Court in Troy, where his HIDA was revoked. So the people are saying they consent to HIDA, but he already previously got HIDA revoked. And so, but because I am keenly aware of individuals suffering from mental health issues, I try my best not to penalize, by jail individuals with mental health issues. I try my best. Sometimes it doesn't work, but I try my best. So what I would like to do, because I don't see him as a good candidate, I really, put forth a lot of effort in. Well, let me change my language. I used to put forth a lot of effort in trying to, get people to stay on the straight and narrow, change, do whatever. And of course, that is met with mixed reviews, which I don't care about the reviews in terms of, people agreeing or disagreeing with my method of trying to get people to change. But when I see that on at least 4 or 5 other occasions, other people have failed at what I'm trying to do, and that's not to say that I don't fashion myself to be able to do it. I do think in these types of situations that Judge Holmes and her team may be better equipped to handle it than me. I'm very happy that he was in some what sounds like intensive mental health treatment. And it's been my experience that so for example, I think you said that he is continuing in mental health treatment. It's been my experience that Judge Holmes they'll work with his present mental health treatment provider. So it's not been my experience that they make a person change from their provider, because when you're dealing with treatment therapy, it's best to have someone like who's familiar with you, who you connect with, so if you connect with the person, we're not going to change it. So what I would like to do, I don't did they say, Mr. Flanagan, how long it would take for them to log in?
They said they had to run the lean in about 5 minutes or so.
I mean, they always tell me that they have to run the lean first, and what I don't know why they do that is because by now they know that I'm not going to send them somebody with. I'm just, okay. Let them run the lean. They're gonna run the lean and make sure I'm not sending them somebody with something that they can't do. But nonetheless, if he's not accepted into mental health treatment court, then I'll do something else. So Ms. White, what I would like to give you the option of, I want to see, I don't know what else is on your agenda for this morning, but I did want Mental Health Treatment Court to get a chance to interview Mr. Wilson. So if you wanted me to have Mr. Flanagan call you when they're done, we could do that, or text you when they're done, and then you could come back, as opposed to just having you wait here, unless you wanted to go in with them. But they're just going to interview him, get some information, explain the program to him, and then let me know if he's eligible.
Yeah, you call or text me. He can
Okay.
call or text me, and I'll be
Okay. So,
Zoom
Mr.
back
Wilson,
on.
this is what I want to do. I'm going to send you to a breakout room, and then when the specialty court coordinator comes in, the case manager, I'll send them in there with you, and then they'll interview you, and then you get to tell me what you think. You know, if you want to talk to your lawyer first before then you could talk to your lawyer first, and then we'll see if I'm going to send you to Mental Health Treatment Court. But I just in advance want to applaud you for addressing some of those issues. I do applaud you for doing that. So accept to join the breakout room, Mr. Wilson, and then hopefully they'll be on in about 5 minutes. Okay.
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 Thank you.
All right. You're welcome, Ms. White. We'll reach out to you.
Okay, I'll be back.
Okay. Ms. Stevenson, I'm ready on. Let's get the jail, and then let's get Ms. Hernandez out of here. So let's do the jail. I'll bring in Ms. Hernandez. And then, okay, so let's see. This is Jeffrey Williams, case number 22-4539401. The people of the state of Michigan versus Jeffrey Williams. Defendant is charged with 1 count of indecent exposure. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina.
Hold on. What happened to the jail? How did they go back to breakout? Okay, let's bring the jail back out. Okay, there they go. Not sure why or how that happened. So let me just recall the case 22-4539401. People versus Jeffrey Williams. Defendant is charged with 1 count of indecent exposure. Today is the date set for pretrial conference. Ms. Ritter, your appearance.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson, on behalf of Mr. Jeffrey Williams. Mr. Williams, sir, when they unmute you, please say your full name.
Jeffrey David Williams.
Thank you, sir. Today is the date set for a pretrial conference. How are we proceeding?
So, Your Honor, I would move for dismissal today. I do have a note about that the court instructed the people to get some information about who the complaining witness is, whether or not that individual is a Wayne County Jail employee.
Ms. Ritter.
So, Judge, it looks like, according to the notes from Mr. Henderson, I don't see the information on whether the complaining witness is an employee of the Wayne County Jail.
You say you don't see the information. What do you mean? Okay, so I'm not sure what that means, though, Ms. Ritter. So today is the date set for pretrial conference. It is the second scheduling of the pretrial conference. I think I remember, based on Ms. Stevenson's statement, that I did have a case where the incident occurred in the Wayne County Jail, and so therefore I said that if it was a Wayne County sheriff, well, of course not the Wayne County sheriff, but if it was a deputy sheriff, that I wasn't going to require their appearance. But if it wasn't a sheriff, then the complainant would have to appear. So you're saying the people don't know if it was a deputy sheriff?
No, Your Honor, Mr. Henderson didn't involve any notes whether he inquired on if the complaining witness was a Wayne County sheriff.
Your Honor, according to the complaint lists the complainant as James Jones, and the investigator's report refers to that individual as an inmate. I would therefore move for dismissal for the complainant's failure to appear.
Today is the day set for pretrial conference. Well, before I do that, deputy, is there a deputy near Mr. Williams? I mean, that name is so common though. So I don't know how they gonna, why do the jail keep disappearing? What is the jail doing? Oh, there they go. Deputy, okay, Ms. Stevenson, does the investigators report, other than listing the person as an inmate, does it list their inmate number?
Let's see. Yes, it does, Your Honor.
Okay, deputy, I don't know what they're doing. Good morning, Ms. Hernandez.
Good morning, Your Honor. How are you?
I'm well, thank you. We'll be ready on Lannis in one moment.
Perfect. I'm just out of the video because I cannot change it from here.
Yeah, I just enabled it.
Okay,
I had
perfect.
it.
No problem. Okay. I look better in that picture.
Me too, Miss Hernandez. Me too. Look, it's a young, look, my picture is, it's a younger version of me.
Yeah, mine too.
The jail cannot unmute. Why? Why can't the jail unmute? Okay, hold on. Well, I can't unmute you. You got to unmute yourself. You have to unmute yourself. I can't unmute you. Okay, is the jail unmuted now? I can't.
Yes, Your Honor, it is.
Oh, okay, there we go. So, deputy, is it possible for you to check? If I give you an inmate, is it possible for you to check to see if you all still have the custody of this inmate?
Yes, Your Honor.
Okay, Miss Stevenson, even though I know it's not, well, Miss Ritter, let me not let Miss Stevenson. Miss Ritter, do you have the investigator's report?
I do, Judge.
Okay, so can you get the inmate number to give to the deputy?
Yes, Your Honor. Judge, it looks like the copy that I have, the inmate number is redacted.
Well, how do Miss Stevenson have an unredacted inmate number?
Can I just get the last name and first name, please?
It's a very common name, deputy. That's why I was trying to do something different. But Miss Ritter, what's the name of your witness?
James Jones.
Exactly. A very common name. But see if you have any James Joneses in your custody.
Do we have a date of birth for Mr. James Jones?
Right, no. Miss Stevenson, can you give me the inmate number again?
Check his housing. See if he's on.
Let's see if I want to know how Miss Stevenson has an unredacted copy, but what's the inmate number that you have, Miss Stevenson?
21-4545.
Your Honor, that person is not in our custody.
Okay, thank you. All right, so with respect to Mr. Williams, today is the day set for the pretrial conference. The complaining witness is not a deputy sheriff and in fact was a former inmate at the Wayne County Jail. Therefore, he is required to appear today. He has failed to appear. People have no explanation for the failure to be able to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Mr. Williams, we're going to send over to the jail a copy of the dismissal for your records. Have a great day and stay safe. Oh, you're muted again, and I can't imagine what you need to say, but I'll send you to the breakout room and you can ask Miss Ritter. I mean, oh, no, sorry, Miss Ritter. She like, I'm not no defense attorney. You can ask Miss Stevenson. I'll send the jail back to the breakout. Good morning, Mr. Page, who I didn't recognize in person when he came in to the courtroom.
Good morning.
All right,
How are you?
I'm wonderful, thank you. How are you?
I'm good.
Mr. Page, I'm going to send you to breakout room number 10.
Okay.
Ms. Stevenson, go ahead and see what your client wants and then come right back.
All right. The court scheduled this to announce its decision. The parties submitted briefs, gave them an opportunity to do that. A transcript of the motion to suppress hearing was prepared and filed with the court on November 12th. The state and defense both filed briefs on December 9th. The court has reviewed the transcript. The court has reviewed both briefs, as well as some of the case law cited in the briefs, and it looks like we're ready for decision. But before I announce my decision, is there anything more either attorney wanted to add, or any reference the court, or you wanted to bring the court's attention to? Mr. Curtis Brown?
No, Your Honor.
Mr. Holland?
No, Your Honor.
All right. As both parties know, the court is somewhat constrained at this time, trying to extricate itself from the office while my AA schedules me for every moment of every waking minute, trying to get cases done before I leave the bench. And so I don't have time to write an opinion, and it's not in any way to reflect that this case isn't important. It's just I don't have the time. And so what the court's going to do is this. The court reviewed the law. And the law, even as the state noted, the state cited U.S. versus Guerrero and State versus Moore, which both hold that for consent, for instance, for blood or for a search to be given, two things need to be proven. One, the consent must be unequivocal and freely given, and second, without duress or coercion. All right. So the court recalls the officer's testimony. First thing I want to point out is this. The court knows that this officer had no evil intent, malice. In fact, I'm reminded of the famous line, "No good deed goes unpunished." I think this officer was bending over backwards trying to assist this defendant in the decision regarding whether to consent to a blood test. And what he was doing was referencing the defendant to the law as recited in the warnings, the DC 70 warnings, which was, if you don't give us the blood test, you're going to lose your license for a year. If you give it and you fail, you only lose it for 30 days. And the officer knew he had a CDL, but the officer admitted he did not know what the law was regarding CDLs and was not aware of what the consequences would be. But he was, in his own mind, the court believes, and I know that's speculative for me to believe what's in somebody's mind, but I think his testimony demonstrated he was trying to be helpful. However, in the process of being helpful, the court has to determine whether this was an equivocal consent or whether it was done duress or coercion. Now, duress or coercion connotate somebody did something really wrong or evil, and that's not necessarily true. You can coerce somebody by being nice. In fact, that's probably the best way to coerce somebody, is by being nice. And the court's going to find that under these circumstances, the officer, I want to point this out too, and I find this interesting. In reading the cases, if it's a Fifth Amendment right to counsel, the courts have held the defendant can equivocate all he wants. But when it comes to consent to a search, you can't equivocate. It's got to be unequivocal. I suppose that'll be explored by the courts in more detail later, but I find that to be a bit, well, I'll just leave it as interesting. If you read all of the cases regarding the defendant's assertion to his right to counsel, the courts have said, well, he equivocated. So he equivocated. That's not the same as an affirmative representation that they want an attorney. So that doesn't vitiate the requirement. But when it comes to a search, it's got to be unequivocal. And that's what's clear. And even the state recognizes that in its brief. In this case, the court's going to find that the consent of this defendant was not freely given, and it was to some extent coerced, but not in an evil way, but it was coerced. And the court relied upon the transcript and its memory of the officer's testimony. And Mr. Holland gave a very good summary of the important parts of that testimony in the brief he filed with the court. And then when you really boil it down, when it finally got down to where the defendant was denying or saying no, then the officer said, well, look, we're going to get a search warrant and you're going to have to give us blood. And Mr. Holland drew that out on his examination of the officer. Well, that's not necessarily true. We all know you can't force a needle in somebody's arm. The United States Supreme Court's made that very clear. So the fact that they get a search warrant doesn't mean the defendant has to give the blood. If the defendant refuses after a search warrant is obtained, it may result in additional criminal charges, interference with law enforcement because of the execution of a search warrant. But they left this defendant with the impression that he had no choice. That's really what it boiled down to. And this defendant wasn't being obstructive. He wasn't being argumentative. He wasn't being particularly difficult. He was just being confused. And so the court's going to find that under these facts and circumstances, the court cannot in good conscience find that this was a free and voluntary consent without coercion. In fact, just the opposite. And so the court will grant the defendant. And again, Mr. Brown, I want you to relate to the officer that the court is not in any way disparaging him, that he had somehow done something with evil motive or intent, but he definitely killed this defendant with kindness to the extent that he coerced a consent. And on that basis, the defendant's motion to suppress the search of his blood will be granted. Mr. Holland, since you prevailed, you will prepare the journal entry rather than Mr. Curtis Brown. Is there anything further needed by either party? Mr. Curtis Brown?
No, Your Honor.
Mr. Holland?
No, Your Honor. I'll prepare the journal entry.
And you might put in there, in case this goes up on appeal, I don't know whether the state will appeal it or not, you might put in that in the journal entry, the remarks of the court are adopted and incorporated so that they become part of the journal entry.
I will do so, Your Honor.
All right. Thank you, counsel. With that, we will be adjourned.
Thank you. Thank you.
Presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also the adjoining case that was with it was a possession of marijuana, which was dismissed prior to even we having these hearings. Okay, I'll continue on. Failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Protects against, due process clause protects against arbitrary government actions, include unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit or proper cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit or proper cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of proper cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony, affidavit, or proper cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in the defendant's motion.
Agreed. Sustained. Move on, Mr. Bay.
Okay. Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed. Case dismissed under the fruit of poisonous tree doctrine, and that's Wong-Sun versus United States, followed by citation. This doctrine.
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong-Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like proper cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of proper cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to this these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed for the reasons stated before.
All right, Mr. Bay, thank you. Your time is up. Your 10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was Antoine Davis Bay at gmail.com.
Will you
Okay.
spell that, sir?
That's ANTOINE last baby at gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did
So
you
the police,
request it? Who did you request it from?
the Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That in and of itself constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, counsel. Mr. Bay.
Can you please?
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State, And then he even cites additional case law, Cameron v. State. So it is cited in there, overruled. Continue.
Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time, the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time defense or the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate. So he's claiming he has not had he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Oh, yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Born v. State, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, in that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process. If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion, rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee that we protect these rights as strongly as possible. Again, if the defendant were so inclined, by perhaps appointing him standby counsel.
Anything further?
I have nothing further orally, Your Honor. I've made my points in my response to the defendant's motion. Again, this court unquestionably has jurisdiction per the Texas Government Code, as well as the court, or the Code of Criminal Procedure. Additionally, based upon the case law I provided in my written response, as well as orally on the 7th of this month, I believe the case law supports the further prosecution of these cases.
All right, Mr. Bay, although you have used your 10 minutes, I will permit 1 minute of rebuttal.
Thank you. First thing I want to address is the due process of that was violated. The prosecutor mentioned that I had a probable cause hearing at the time of the bond. That wasn't the hearing that I alleged that was a violation. I never received preliminary hearing. Never even entered a plea of guilty or not guilty. That hearing had never happened. We initiated this case back in, bond was filed in March 10th, just looking at the docket sheet, Judge. March 10th, 2021. Bond was filed. A hearing for the initial preliminary hearing was not called. The complaint was not even filed until April 27, 2021. So that was a whole 2 months after I was even released on bond, before a complaint was even filed, and no hearing was ever scheduled. A hearing was scheduled for, I'm looking at the docket sheet, a hearing was scheduled for 7/23/2021. It was 2 hearings because at first it was 2 judges. Christopher Morales and another lady judge. Her name was, and excuse me if I don't have her name right in front of me. But the other case was counseled. The cases was at the same time. So one case was counseled, the other case, I guess, was still heard. And that's when the warrant was issued. But that hearing, we never had a rescheduling that hearing. Once I was arrested again on the warrant and bonded out, that hearing never had took place. Also, okay.
That was 2 minutes, actually. So,
all right.
I'm ready to rule. And then I have a question for you as well, Mr. Bay. So I'm going to deny your motion to reconsider. We're going to proceed with trial. And sounds like my understanding, you have had access to the discovery since October 19th. However, he is going to resend everything to you for you to review. My question to you, Mr. Bay, is would you like standby counsel to advise you during trial? They cannot ask questions of witnesses or assist you in that way in the trial, but they can provide advice to you to help guide you through the process.
Yes, I'm not waiving any right to counsel. I do reserve my right, Sixth Amendment right to reserve.
You've already waived the right to counsel. You stated you wish to waive your right to counsel and you wanted to represent yourself. We had a whole hearing on that, Mr. Bay.
Okay, so you're asking me, do I want to?
I'm asking you if you've stated you want to represent yourself, Mr. Bay. Okay, we had a whole hearing on that. You waived your right to court-appointed counsel, and you stated you wanted to represent yourself throughout this hearing. And I have confirmed that in almost every hearing that we've held in this case. Now, what I'm offering at this point in time is you can still represent yourself in this matter, but the court would appoint a standby counsel who could advise you during the trial. They're not going to participate in the trial, meaning they're not going to ask questions of witnesses. They will not conduct voir dire, but they will advise you regarding certain legal rights that you may have or on legal matters that may arise during the trial. Would you like the court to appoint you a standby counsel?
Yes.
Yes. So you are asking the court, I just want to confirm, you're asking the court to appoint you an attorney who will provide you advice through the course of your trial, which shall begin on December 3rd.
And I also request that I reserve all my rights. Yes, that's a yes to that question, and I reserve all my rights.
I'm not, well, you waived your right to court-appointed counsel already with that whole hearing we went through. But I'm still giving you a court-appointed attorney to advise you, okay? You understand?
Well, I never waived my right to the Sixth Amendment. To the Sixth Amendment.
I can have my court pull the record if you like, Mr. Bay, but we're not going to, I'll tell you what. Do you want to continue to represent yourself?
Yes, I mean, I answered your question. Yes.
Okay. Well, you're stating that you don't want to waive your right. Okay, here's the thing. Do you want court-appointed counsel that's going to represent you during the course of this trial?
Like I answered the question. I said yes, I would take standby counsel, represent myself.
You're going to take, so you still want to waive your right to court-appointed counsel and continue to try this case yourself, but you're willing to accept standby counsel to provide legal advice only during the course of the trial. Is that correct?
Correct.
Okay. All right. Okay. We shall proceed on December 3rd with trial. I will have standby counsel appointed to you. They should reach out to you shortly. Mr. Bay, I believe we have a phone number for you. Do we?
I did not see it on the docket control order, Judge. Let me just verify that.
All right. All we have is an email. No, we have a phone number as well in the docket control order. All right. I will have the attorney that I appoint as standby counsel contact you through your email and the phone number you have provided to this court on the docket control order. Okay, Mr. Bay?
All right.
Very good. All right. That concludes today's hearing. You're free to go, Mr. Bay. We'll see you on December 3rd for trial.
Your Honor, if I may, before we let defense go, I know defense, I believe it's been rejected by the clerk's office. That being said, I did see it. I believe he has filed a motion to suppress. I wanted to raise that to the court's attention. Would you prefer having that prior to trial, or would you prefer it run with trial, Your Honor?
We'll carry it with trial at this stage.
Yes, Judge.
We don't have enough time to hear it beforehand.
Yes, Judge.
Also, can I make a note that I will be filing a notice to appeal this order, and can I get this order for in writing to preserve my notice to appeal?
So I made a docket entry. Do you have an order that you have submitted to go along with your motion to reconsider?
No, I didn't.
Okay. Mr. Bay, I'm going to ask you to file an order that goes along with your motion to reconsider. I'm denying it regardless, and I'll make a note of that on the order itself.
Okay.
All right. I'll see you on December 3rd, Mr. Bay.
All right.
All right.
All right, this is a motions hearing in Quintero versus Precision 2000. I assume you all do want takedown, yes?
Yes, please, Your Honor.
Yes, Judge, we'll share and take down.
Okay. Let's start here. I've reviewed the motions challenging expert qualifications and opinions. I don't really need extensive argument on those. I think I know what I am planning to do with them. But I'll give you a chance to go through this in a nutshell. What I don't want is a point by point on every opinion of every expert. I don't need that.
Understood, Your Honor.
I mainly want to hear about the summary judgment motion. So I mean, if you want to cover the expert motions briefly, that's fine. Unfortunately, I'm having a little difficulty pulling up the case on Odyssey. or pulling anything up on Odyssey. But that's fine. I've got my arms around them, at least as of yesterday. So go ahead.
Well, thank you, Your Honor. Nicole Leet here for Defendant Precision 2000, also known as P2K. We brought these motions, and actually one of my first questions was going to be to Your Honor if you would like oral argument on those Rule 702 motions. I will focus my oral argument on the motion for partial summary judgment in this case, which P2K brought for really three main reasons. One was the claim for conscious pain and suffering. One was the claim for punitive damages, and then to address a point brought up in the response, a claim for pre-impact damages. Just briefly, the facts of this case are pretty distinct. This case involves an automobile accident where the deceased plaintiff, Stevie Bryant, was a passenger in a Mercedes driven by her boyfriend, Lloyd Acano. As they were driving down the connector, another vehicle, a truck driven by Carl Anthony Smith, veered over and shoved them off the road, sending them into an uncontrolled spin, which resulted in them hitting a concrete barrier. The allegations in this lawsuit focus on that concrete barrier. The plaintiff has sued a contractor, P2K, alleging that they improperly installed an attenuator.
Right. There's a plastic part of it that is supposed to be filled with water, right?
Yes, Your Honor. And that is what P2K installed. There's no dispute there. That's where P2K comes into this scenario. The evidence shows that after the time of impact, Stevie Bryant was unconscious and never regained consciousness. Therefore, P2K moved for summary judgment on the conscious pain and suffering claim because, of course, as the name of that claim implies, it requires consciousness, and there is no evidence of consciousness. Now, in the response brief, plaintiff seems to assert that they're also going to bring a claim for pre-impact pain and suffering and the fright of the impending impact from the time that the Acano's vehicle was shoved off the road by Carl Anthony Smith to the time of the impact and death. That is interesting because that's not what this case is about. This case was brought solely against P2K for P2K's negligence, and there's no allegation or claim that P2K had any involvement or relationship with Carl Anthony Smith, leading him to push Mr. Acano's vehicle off the road. So from the time that Mr. Smith pushed Mr. Acano's vehicle off the road until impact with the attenuator device and or the concrete barrier, P2K was not involved. This case was brought solely against P2K for P2K's negligence. Therefore, as an additional ground for the summary judgment motion, P2K would move to say that there can be no claim for any pre-impact with the attenuator damages because P2K was not involved. That's not what this negligence claim is about. Plaintiff has appeared to argue that this case defaults under Hatcher to a joint and several liability claim, which is a bit of a novel theory. We would respectfully point Your Honor to the longstanding case law that no, joint and several liability is a specific claim that needs to be specifically pleaded and evidence presented, which it has not been done in this case. It was never pleaded as a joint and several claim. Carl Anthony Smith was not mentioned in the complaint. The complaint was brought against P2K for P2K's negligence. Hatcher does not say that the default is now joint and several liability for every claim brought within this donut of the period with the legislature's ruling on apportionment before they fixed it with the statute. That's not what Hatcher says. Hatcher merely does away with apportionment. We understand that. There is no apportionment here in this case, and no non-party notices of fault have been filed. But the case itself is against P2K for P2K's negligence. It, again, has not been pleaded nor proven, nor really can it be, that P2K acted in concert or was somehow related to Carl Anthony Smith, this other driver, and caused him to push Acano's vehicle off the road. There is a logical and rational delineation between Mr. Smith pushing Akana's vehicle off the road, that impact and its result, and then the impact with the attenuator and concrete barrier. That is what plaintiff pleaded. It can be done. That's what's been litigated for the past couple of years, and that's what we're dealing with. So to the extent there is going to be any claim for pre-impact, post-impact with Mr. Smith's vehicle, but pre-impact with the barrier damages or claims, P2K would respectfully request that those claims be dismissed because that does not involve any duty, breach of duty, or allegation of negligence against P2K. And finally, as Your Honor has seen, it was pretty well briefed. P2K moved for summary judgment on the issue of punitive damages. One, as related to the claims above, it doesn't support a claim of punitive damages. But two, P2K has presented that there's no clear and convincing evidence to support such a claim. The claims brought were for negligence. There's no willful or malicious or consciously indifferent to consequences, clear and convincing evidence that has been presented, and there still isn't before this court today. So respectfully, P2K would move for summary judgment on all of those issues.
All right, response?
Yes, Your Honor. Caleb Walker for the plaintiffs here. I'll start with the pre-impact pain and suffering issue. I mean, we responded to the defendant's arguments that they can't be responsible for pre-impact pain and suffering. Everyone agrees that there was pre-impact pain and suffering. And the evidence, in fact, is that Stevie Bryant, the decedent, was screaming in fear, and that we don't know exactly what she was aware of and what she saw because she's dead now, but her fiance, Mr. Akano, who was in the driver's seat, she was in the passenger seat, testified in his deposition a couple times that after being hit by the Dodge Ram and the car being spun out of control, he remembers seeing the concrete wall approaching. He remembers hitting the concrete wall, and he remembers the airbags deploying. That is sufficient evidence from which the jury can conclude that Ms. Bryant would also have been aware of the concrete wall, aware of the impact, felt the impact. There's no allegation that she lost consciousness before the impact with the concrete wall. So the idea that she was only afraid because the vehicle was out of control from being hit by the Dodge Ram is not undisputed by any means. The evidence is that she was afraid for her life, and the jury can conclude that she saw the concrete barrier coming. And the allegations against Precision 2000 here are that if they had properly installed a 4-module impact attenuator, the car that Stevie Bryant was in never would have hit the concrete part of the barrier. It would have either been stopped by the impact attenuator, or it would have the impact attenuator would have gated through and the Mercedes would have come to rest on the other side of the concrete barrier. But either way, there's no impact with the concrete barrier absent Precision 2000's negligence, according to the plaintiff's theory of the case. So the point of that is the evidence is that Stevie Bryant, or the jury, is absolutely entitled to conclude that she knew she was about to hit what actually killed her and would not have killed her absent the defendant's negligence. And really, you know, we've briefed this.
Well, are the facts of this case that the attenuator was there, it just was not properly installed, so to speak?
Well, so there are multiple modules, and our position is there should have been 4 modules. There were only 2. The modules, 3 of the 4 modules should have been filled with water, and the entire 4-module unit should have been anchored to the concrete barrier, which it was not even anchored to the barrier.
Okay, but with regard to pain and suffering then, though, I mean, all that the decedent is aware of at the after the time the 2 vehicles come into contact with one another, but before the vehicle hits the barrier, is that the vehicle is heading toward a barrier, not knowing, not knowing that it would not work properly. I mean, I don't know. Of course, I'm sure none of that is in evidence in the case, though that'd be the plaintiff's burden, I suppose. I guess it's really only after impact with the barrier then that the pain and suffering caused by the barrier comes into play. And then I know what the defense's arguments are there. But I mean, I do have, I guess, a question for the plaintiff. I mean, isn't that really when the negligence of Precision 2000 comes into play, is when the vehicle hits the barrier? I mean, otherwise you're just headed toward a static object. And the fear is really just the fact that you're spinning out of control, heading toward a static object, right?
I understand your question, and I do disagree with that. So the fear of death it's not a cause of action. Pre-impact fear is not its own cause of action. You can't sue just for mental pain and suffering because you were afraid you were going to die. What it is it's a part of the general damages that are recoverable for the physical injury. So if you don't have a physical injury, you can't recover for mental pain and suffering. That's
well, right. So we're only talking about after the vehicle. Then that gets to my point. We're only talking about after the vehicle hits the it's the time between impact and in this instance death, right?
No, I mean, for instance, in the Monk versus Dial case, 212 Georgia App 362, the Court of Appeals explained, contrary to defendant's assertion, we find no requirement that the physical injury precede the mental pain and suffering. And essentially it says the fright, shock, and mental suffering experienced by an individual due to wrongful acts of negligence will authorize a recovery where attended with physical injury. So the physical injury is the cause of action.
But okay, so and that again, I'm trying to kind of get to the act of negligence here. The negligence is in the design, well, I don't know if it's not really the design. It's in the installation of the barrier, right? So the result, the pain and suffering that flows from the negligence only comes into play at that moment of impact, doesn't it? Otherwise, you don't know anything about what's going on I mean, you just know that you're spinning out of control toward a static object, and that's what you're perceiving at that point.
So
not anything about the static object itself.
So there's not a requirement under Georgia law that you know exactly what's going to cause your death or how you're going to die, or even that you conclusively know you will die.
I've got all that. That wasn't my question. My question is, I've got all that. My question is, it only begins to flow from the act of negligence when you hit the barrier, right?
No,
the act of negligence is the improper installation of the barrier.
So I disagree that there has to be impact with the barrier before the damages are recoverable against this defendant. So the damages, if you prove a physical injury, you're entitled to recover the pain and suffering related to the physical injury. Georgia law in Monk versus Dial says that includes pain and suffering related to the physical injury that may occur before the impact. So with Precision 2000's negligence being a contributing proximate cause of the injury, we're entitled to recover the damages related to the injury against Precision 2000. And that gets into the issue of this being a case that's governed by the Austin and Byrd apportionment decision, because what I was in law school when the apportionment statute was passed. So I learned about joint and several liability as the default in 2004, 2005. And the way it worked prior to apportionment is there could be multiple contributing proximate causes of an injury. You could sue any one of the parties responsible for an injury and recover all the damages related to that injury from that party. And if that party considered that someone else was responsible for part or however much of the damages, they brought a claim for contribution against that defendant. So here, the injury is a fatal injury that resulted in death. It's not a divisible injury that could have been separated out absent application of the apportionment statute. So under Austin and Byrd, we're entitled to recover all damages related to the injury from Precision 2000 if they believe that most of the pain and suffering or all of the pain and suffering or so forth is the responsibility of the driver of the Dodge Ram. Their remedy is to bring a claim for contribution against that driver.
All right.
So I think we've established our position on the pre-impact pain and suffering. And I understand the court's concerns, but I don't want to belabor the issue. On the issue of post-impact pain and suffering, there are cases that use the phrase conscious pain and suffering, but those cases do not set out a test that requires a plaintiff to prove that a decedent was conscious, was responsive, etc. In fact, the default rule is Georgia law presumes that where there is a physical injury, there is pain and suffering, and the jury can award pain and suffering without any additional proof of pain and suffering other than the physical injury. So proof of the physical injury is enough to survive summary judgment on its own without any additional evidence, unless the undisputed facts show conclusively that death was instantaneous and there could not have been any pain and suffering. And we've cited, cases. I think the most comparable case, I'm sorry, I have to get my other stack of cases here. The most on-point case that we've cited, I think, is Beam versus Kingsley, which is 255 Georgia App 715. And the evidence of pain and suffering there was, I'll just read the quotation. He survived for as much as 2 minutes after the crash and could be heard choking and gasping for breath as he drowned in his own blood. The evidence supported an award of damages for pain and suffering, and we cannot say that the amount of damages was flagrant, etc. So here we absolutely have evidence that Stevie Bryant survived the impact. She did not have any head trauma. The fatal injury was massive internal hemorrhaging that essentially caused her to bleed to death. She was breathing on her own up to 35 minutes after the impact when she was extracted from the vehicle. The medical record describes it as agonal breathing, which is a medical term that essentially means gasping for breath in an attempt to survive. And she didn't actually die until 2 hours later during emergency surgery, where they tried to, they gave her many units of blood. They tried to, perform surgery to repair the hematoma. She lost a pulse at one point. They restored the pulse, they restored blood pressure, but she ultimately passed away 2 hours later. So there's no question that this was not an instantaneous or immediate death. And really the only statements that the defendant relies on are Mr. Akano's deposition testimony, where when he regained consciousness after the impact, he says Ms. Bryant was not responsive, that she was not talking or moving, but she was looking at him, and that he was dazed still from the impact, and that he was helped out of the vehicle by bystanders. and after that, he doesn't know anything additional about her condition. So, you know, under the default rule, which is where there's a physical injury, the jury may award pain and suffering, absent immediate death. There's a great amount of evidence to surpass summary judgment. I mean, the jury is welcome to consider the arguments that she was unconscious or that there's not enough evidence that she was conscious or responsive, etc., in considering the amount of pain and suffering, but it's not a situation where summary judgment is appropriate. Absent conclusive medical evidence that death was instantaneous is the standard. And we've cited a number of cases where there's consciousness for 15 seconds after an injury, that a faint pulse within minutes after the injury is enough. So it's clear that there's much more evidence from which the jury could reach a conclusion of pain and suffering during certainly the 35 minutes plus where she was breathing on her own, had a pulse without CPR, resuscitation, etc. So there's definitely evidence of pain and suffering after the impact. And again, I do want to be very clear that there is a presumption based on a physical injury that is enough to support an award of pain and suffering unless it's conclusive that there absolutely could not have been pain and suffering. So, even without additional evidence, essentially the evidence of survival is enough under the law for the jury to award pain and suffering. And finally, on the issue of punitive damages, this is, as we've discussed in our brief, this is not, from our perspective, certainly, a case of simple negligence. This is a case where nobody in the entire organization of Precision 2000 knew how these barriers were supposed to be installed, had any training on the installation, and certainly did not follow the manufacturer's instructions on how to properly install the barrier. And that's important because the instructions are really not, they're not advice. That's how the barrier has to be used for it to function properly. And it undergoes extensive testing by the manufacturer and approval before it can be used in this setting. And it's the industry standard, and it was required by the contract with the Georgia DOT that it be installed appropriately according to the manufacturer's requirements. And Precision 2000 did absolutely nothing to even try to meet that industry standard. The workmen on site did not know how to attach it to the concrete barrier. They didn't fill it with water. The foreman says he told them to. They say, well, we don't remember him telling us to, and nobody filled it with water. Even the safety director for the company admits there was no training of anyone on how to properly use this attenuator, and that he didn't know how to do it himself. So under those circumstances, that would entitle a jury to conclude by clear and convincing evidence that was conscious indifference to the consequences. Essentially, that everyone agrees this impact attenuator is required as a safety precaution, but Precision 2000, I guess they at least knew that the impact attenuator existed, but they took no steps at all to use it properly. They did no training. They didn't even try to figure out how to use it properly. And they knew that if it wasn't, but it was for protection of motorists. And so they knew that if they didn't install it properly, it was going to be a threat to motorists on the highway. So that is conscious indifference to the consequences. And I think that's absolutely a jury question on the issue of punitive damages.
All right, Ms. Leet, a short reply. Sure.
Thanks, Your Honor. I would like to address a few things. One, earlier on in the argument, plaintiff's counsel referenced Lloyd Econo's testimony about what he saw after Carl Anthony's vehicle struck him and sent his vehicle into the uncontrolled spin. Just to clarify, there is no testimony distinguishing between I saw the attenuator device versus the concrete wall. It just says the wall. And in the deposition testimony, everyone calls it the wall, meaning both the attenuator device and the concrete barrier. There is zero evidence or testimony that Mr. Econo or Stevie Bryant saw the attenuator device, saw any issue with the attenuator device, had any inkling or knowledge of the alleged acts of negligence of P2K in this case. This is a simple case of, duty breach.
But I mean, so Ms. Lee, let me flip that question around on you then. Plaintiff cites case law that said, I think even though plaintiff wasn't really willing to acknowledge what the premise of the question that I was asking, ultimately, it is ultimately not it's just the anticipation of hitting an object that is the pain and suffering that kind of that comes into play prior to the impact. But then at the point of impact, there's a negligent installation of the barrier that, from which, damages flow. But, plaintiff then has cited some case law that says that, once you have that, the pre-impact pain and suffering does, come into play. And the defendant can be held liable for that. So are you saying, you do acknowledge that the law provides that, right?
No, Your Honor, I explicitly disagree with that. In the case referenced by plaintiff's counsel, this Monk versus Dial, and in fact, all of the cases, none of them deal with the situation which we have here, which is fairly unique in that specifically Monk v. Dial, the court recognized this was a two-party crash, a car coming down the highway hit a tractor trailer. And the court specifically said there was evidence that the car coming down the highway saw the tractor trailer, tried to avoid it before the impact. Therefore, pre-impact pain and suffering could be had, even though there was no real evidence after the crash of any issue. What we are dealing with here is not a situation where anything P2K did, a breach of duty, could have led to Mr. Econo's car coming out of control to hit the barrier. I have not seen any cases on point in this kind of unique situation because the case, again, is just against P2K. So merging pre-impact pain and suffering with post-impact pain and suffering, it cannot be done in this situation because there is a clear delineation of when P2K's alleged negligence comes into play. And as Your Honor pointed out, it's at impact with the attenuator. From that point on, I would agree that post-impact with the attenuator and / the wall, that is where the damages come in against P2K. Now, that is a separate basis for our motion for partial summary judgment. We have moved that there's no evidence of consciousness past that point. Therefore, they don't get that pain and suffering portion. But to address the pre-impact confusion, all of the case law I've seen and this Monk v. Dial case cited by plaintiff merges pre-impact with post-impact because there is specific evidence of recognition of the involvement of the negligence of the party there beforehand, cause them to swerve, cause that. Going to the consciousness, I would disagree a bit with the recitation and account. The problem here is there is no evidence of consciousness, and it's not a made up requirement. The term is conscious pain and suffering because it is what is felt by the person, which requires consciousness. And all of the evidence is that Miss Bryant had a GCS, a Glasgow Coma score of 3, which is completely unconscious and unresponsive at all times. The reason we rely on Mr. Econo's testimony is because he was the one in the vehicle. And he did not testify that Stevie Bryant was looking at him. He testified that her eyes were open and she was not seeing him. They were fixed, and there's no evidence of consciousness. So just to address those points.
All right. Anything further?
Not on this one, Your Honor.
All right. I will give you all a written order, actually written orders on everything. So, so just be on the lookout for those, and, you know, we'll get you set for a pretrial conference in due course. Thank you, everyone. Happy Thanksgiving.
All right, good morning. We're going to get going here. This is the Cowlitz County Superior Court Minor Guardianship docket. I'm going to start first with number 1 on the docket, 23-4-00325-08. That is the guardianship of Donovan Anderson. I see Miss Dow. Who else do I have?
Miss West.
Okay. And so let me pull up the record. I was hoping they were in there as proposed. I don't have the orders in front of me, but there was an issue as far as the papers. In particular, that the language that had been in there on the final orders basically dismisses the minor guardianship immediately. And these phases, you know, as far as that part of it goes, that would be up to the parties to monitor it. And if the mom doesn't do it, then there's no recourse with the court because the case would have been dismissed. So what I typically see are, you know, a particular parent will do phase 1 and then phase 2, whatever the steps are. And then if that person successfully completes these steps, then the parties agree that the case will be dismissed. So it's more of something like that in the language that was in there. So that's why I didn't sign the papers.
Okay, Your Honor, I really appreciate your taking the time for input on this. I was scratching my head over that. So if I understand you correctly, when I redraft the order, there should be no statement that it's terminated. The guardianship should still be in effect. I believe the phasing language is in there, but I will double check that it's very clear. Should we then say that the plan was the last thing that we were looking for an actual enforceable court order, I think was some time with Ms. West on December 24th. Should I maybe target the letters to expire and the guardianship? I just won't even say that the guardianship is terminated. I'll put in a target date for the letters to expire at the end of December.
That would make sense.
Okay. Was there any other issue that you saw with that order?
Unfortunately, I don't have it in front of me. I don't recall any others, but I just know that it was being dismissed immediately and there was no recourse if somebody didn't do what they said they were going to do.
Okay. Then unless you want to direct us otherwise, I will just have a conversation with Ms. West and Ms. Melton, make sure that the order reflects what everybody understands we're going to do, and I'll submit another one.
Okay. Ms. Melton, are you good with that?
Yes, I am.
Okay. All right. That takes care of the matter as far as today.
All right. Thank you very much, Your Honor.
Thank you.
Thank you.
All right, going to number 2 and 3 on the docket, 24-4, 281-08 and 282-08. This is the minor guardianship of Chance and Dayton. And who do we have present on these matters?
Carla Snyder.
Amy Turnbull, the guardian ad litem for Chance.
Ann Height, court visitor for Dayton.
Okay. All right. So I'm surprised we don't have anyone else. And I apologize. The one that has on the iPad, your name again?
Carla Snyder.
Okay, thank you. All right, so I did see this is a motion to modify or terminate the guardianship of Chance and Dayton. And the court had a chance to go back and look over things. And the court appointed the court visitor for Dayton of Ann Height, and court appointed the guardian ad litem for Chance as Amy Turnbull. And you know, when I looked at things, it comes off to the court that the mother wants to see the guardianship immediately dismissed, and the court simply doesn't see that in the best interest of the children, no matter what. Does anybody know where the other party is by chance?
I do not.
Okay, all right.
She should be. I'm not sure why she's not on here, because usually she gets on the Zoom, but I couldn't tell you why she's not on this morning.
Okay. All right, well, we'll go ahead regardless. So first off, as far as the guardian ad litem for Chance, Ms. Turnbull, where are you at with things? Do you have what you need? Are you needing anything?
Well, I have spoken with Ms. Schneider. I've spoken with Mom. I've spoken with Chance. I've done a home visit. And I can tell you that Chance enjoys his visits with Grandma. He wants to keep them up. He, if anything, I think he'd like more time with Grandma. What has come to my attention are some serious concerns with the stepfather in the home. And I have not had time to look to see if those concerns were known to the court at the time when the custody was given back to Mom. Ms. Schneider has made me aware of some things that happened, some very concerning, explicit and lewd text messages that were sent to her by the stepfather after the children were returned to home, and significant criminal history of stepfather. So I do have some additional concerns about Chance in Mother's home that I don't know if the court wants me to continue to investigate. I don't know how much the court was aware of it when they put Chance back into the home, but it is concerning to me.
You know, I think at this point, I would like you to go ahead and investigate. I think it's, you know, part of doing what's in the best interest of these children. And, you know, and with that in mind, that's part of it. It may be that under this particular process, we may not be able to do everything, but at least it will be brought to light of that information. And then potentially something done after that. So I would like you to go ahead and investigate those concerns.
Okay, I will do that.
Okay. Anything else that you need at this point?
Not at this time.
What are you thinking as far as your timeline for what you're doing?
Well, if we're going to wait for CPS records, that's going to take some time. I think I can get, you know, the additional information without the CPS records fairly quickly. You know, if we could meet back in 6 weeks, but obviously the CPS records are going to take, you know, 90 days.
Okay. All right. Okay, thank you. All right, and then Ms. Height, I did get your report. I did review it. And my understanding is Dayton does not want an attorney. And you recommend to have 2 weekend visits per month with grandma, as well as an additional day. And that coincide with the cousins, of up to 4 per month and a week-long visit in the summer. Are you recommending that go in place immediately? I'm somewhat concerned without mom present, but and hearing from her, but I didn't know if you talked to her about it.
I did not talk with her specifically about that because I made that recommendation after our visit. Hearing what I've just heard from the guardian ad litem, I do have additional concerns, and considering especially the length of time that looks like this case is going to take, I would like to bring up for your honor of an overriding concern, and that is the schooling of these children. They are currently being homeschooled. Up until this school year, they were in public school. Dayton was very specific, and in fact, his strongest statements about this whole situation, which he seems to be pretty conversant in, was that he wants to go back to Monticello school. And I frankly don't believe that the household lends itself to a good homeschooling environment. And I believe it would be in his best interest to go back to public school at this time. And I know that's outside of the scope of my orders, and I am reluctant to step outside of what your honor asked me to do, but I feel strongly enough that I would like to bring that to your attention this morning. If this case moves at the pace it's going to be, he will be further behind if that is the ultimate decision of the court.
All right. Ms. Schneider?
Yes.
I wasn't the judicial officer that was involved when this matter reached where it did for the children to go home. I don't know where you stand with things. Obviously, this is somewhat dependent. Obviously, it's very concerning in regard to the schoolings, very concerning in regard to the stepdad. Ultimately, though, that's not before me at this time. And that's really up to you if you would like to bring that before the court procedurally.
Yeah, I just didn't know how to go about stuff. I kind of don't know what I can put in the court stuff, or you know what I mean? I want what's best for the grandchildren. I fought really hard to keep them with me because it was a better environment. They were succeeding, they were excelling, and then this all came about and they were put back with her with no actual proof that she was clean, that it was, you know what I mean? So I don't feel that it happened the way it should happen. I really just I want to do what's best for them. I always have.
All right. So what I can provide you at this point is you can reach out to Cowlitz Wakayakum Legal Aid, and they can give you some assistance. They also have a workshop on Mondays at noon here at the Hall of Justice. Again, from noon to, I believe, 2. It's first come, first serve. And that may be a possible option. There's Northwest Justice Project is another potential option. So there would just need to be some procedural things, like I said, that need to happen to get this back before the court. The issues as being that are concerning, definitely concerning. So at this point, that's what I would suggest that you go ahead and possibly look at. I don't know why we don't have mom here this morning. That that brings up other possible issues. So I think at this point, what I'd like to do, again, Ms. Turnbull, if you can go ahead and investigate, and I think I only had appointed you in the one case, not both. So I
Yeah,
think
only for Chance. Mhm.
yeah, Ms. Height, I understand where you're at as being the court visitor. Do you think you're complete with those duties as far as that's concerned?
I believe I have done what the court asked me to do as far as confirming or investigating modification or termination. I believe there's a lot more to investigate. I believe I've done what I was specifically asked to do.
Okay. So
But
here's what
I have residual concerns.
Okay, so here's what I'm going to do. I think at this point, so we're not doubling up on things, is go ahead and amend Ms. Turnbull's orders to have both children, and then potentially talk to Ms. Height to find out what her concerns are and incorporate those into what you're investigating. And that way we make sure to cover both children from the point of a guardian ad litem. And then Ms. Height, if you feel that you've completed those duties as the court visitor, then you can go ahead and submit your withdrawal with your request for fees. But I would just encourage you to talk to Ms. Turnbull before you're complete.
Understood, Your Honor. Thank you.
Okay. All right. So what I want to do is go ahead and not set this out too far. I want Ms. Schneider to get an opportunity to talk to somebody and get this back before the court. So we're on the 3rd. Let's go ahead and set this to October 24th.
Is that going to be at 10 o'clock, Your Honor?
It will be.
Okay.
And I'll do a modified guardian ad litem order to include both children. Okay. All right. That concludes this matter for today.
All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right, that brings me to guardianship of Soraya Farrow, cause number 24-4-00301-08. All right, anyone else? We have, looks like, is Soraya with you? You're muted, ma'am. Can you unmute yourself?
She's here, but she's sleeping.
Oh, okay.
And I did tell her it was happening, but she opted not to come, so.
Okay. All right. So we have Ms. Amador, excuse me, and we have Ann Height. Do we have anybody else present today? Okay. Hearing no one. So Ms. Height, you want to go ahead and report at this time? Again, I saw your report. Anything else that you want to add at this point?
No, I think my report is pretty straightforward, and the simple task to find out if she wanted an attorney was pretty easy to figure out, and it was also gave me a good chance to speak with her about some other things. She was very clear and easy to talk to. She has had a lot going on in her young life and seems to have a good grasp of what she needs and what she wants. And I believe I made that clear to the court.
Okay. All right. So, Ms. Amador, how have things been going?
They've been going good. It's always a little adjustment, I think, with a situation like this where you're finally with each other, things start calming down. I think from her side, she's adjusting to the idea that, hey, this is real stability now, and then we're learning how to get to know each other, understand each other, work together, stuff like that. But she's in school and she's working on that. I did get her transferred out here to Maricopa, and she's doing good with that. I'm working on the healthcare. I should be going to find out next week or the week after that, whether or not I'm going to go through military benefits with the court order or my workplace. But we'll get that straightened out. I do have feelers out for therapist. I haven't heard back yet, but I will be checking within either this afternoon or today to find out, why I haven't heard back.
All right, so my recollection and understanding is the mother consents and the father's not found. But the issue is only the emergency minor guardianship is found, but not a petition. Hold on, let me admit this person. But not a petition for a full guardianship. And so that's concerning to me. And that would be the ongoing one. I didn't know if you were just looking for the emergency guardianship, which is a limited guardianship.
May I respond?
Go ahead.
Okay. No, I do want to pursue full guardianship. I do have the paperwork ready. I'm just figuring out how to navigate that from here. So I think I have to mail that in to the court clerk.
Right.
I will be
Can
mailing
you hold
that.
on just 1 second? Okay. I apologize, Ms. Amador. Go ahead.
That's okay. So I'll be mailing that at the latest Monday. But I want to call them and speak with them and see if there's any cover pages or anything I need. I already have all of the paperwork filled out for the full guardianship.
Okay, all right. That was my main question at this point. So we'll just keep the emergency guardianship going on at this point. Ms. Height, do you foresee any further need at this time for what you do or need to do?
I do not see that need. Thank you.
Okay, so if you want to go ahead and submit your withdrawal and submit your billing, that would take care of that part of it. And we'll just go ahead and, like I said, extend the minor guardianship just to kind of monitor to make sure the full petition is done and make sure that everything's covered. Okay.
Okay. So may I address the court?
Certainly.
So when you say extend the full guardianship, is there an expiration date on that, or?
There is on the emergency. It's only potentially good for overall 120 days at the most.
Okay, that's what I thought. Okay.
So that's where I want to make sure that if you're going to pursue the long term, you need that full guardianship petition filed, and we address it there.
Okay, great. And I did locate Dad and I spoke with him, and he is okay with me serving him personally. So for the full guardianship, I'll make sure he gets served.
Okay. All right. Good. All right. Sounds good. So I'll go ahead and extend your letters. Well, right now they're to November 12th. So let's go ahead and just have a hearing on November 7th.
Okay.
And then hopefully by then your other petition is filed and we can address it through there. And then you would have service on the dad, so that should take care of that part of it. Okay?
Great. Thank you.
All right, that takes care of the matter for today.
Thank you, Your Honor.
Thank you. All right, that brings me to the final matter, guardianship of Zephaniah DeMoss. Zephaniah, DeMoss, cause number 24-4-311-08. I have Kaylee Montgomery. Do I have anyone else present on that matter? Okay. All right. So, Ms. Montgomery, have you had any contact with the mother, or where are things at?
So yes, I was able to make contact with her with the phone number she joined court last time. And we did originally, I set up a day and time. I met her where she chose to meet, and we had a pre-agreed time, which I have texts of, and I sat in that area, texted her multiple times, and waited for over an hour, and she never showed up. So then my second attempt was I gave her a time and a place, and I said, we can meet here if you would like to discuss what your plans are. And she didn't reply until it was about 10 minutes before we were supposed to meet. And I texted her again and I said, I won't show up unless you tell me you're coming. And she said, okay, I'm coming. So we met and we talked. It didn't go well. I would say. She told me that she's currently on methadone, which to my understanding means she's in an outpatient program of some sort. Other than that, she didn't have any plan. I did tell her that I didn't see it in the best interest of Zephaniah to have contact at the moment. I told her I would leave it up to him, which in the over a month that I've had him now, he hasn't asked to see or talk to her. He talks about her, which we talk about that, and that's fine, but it doesn't upset him. And he doesn't show any interest in that. She did not like that, and left very angrily. I also did tell her that I didn't want her to be concerned about rekindling a relationship with me, that was not what this was about, and I was not interested. And that if we do have contact from here on out, that it needs to be, meaningful and purposeful regarding Zephaniah. And so since that day, I have not heard from her.
Okay. So I do need to make a record. She did contact our court administration saying she was calling in, and there was a phone number, but I've looked and there is nobody calling in. And so I do not have her online. So at this point, in regard to first, the petition for a full guardianship has not been filed yet, so I don't know if that's your intent. I don't know if you were listening to the last conversation I had with someone, that right now you're just under that emergency guardianship. And if you want to pursue this for a more long-term, you're going to have a petition for a full guardianship filed as well. Otherwise, we have limitations on how long we can go under the emergency guardianship.
Right. And that was one of my questions as well, because I was told that it's 60 days and you can renew it one time for up to 120, but I didn't know if I had to do those first before a full guardianship or not. So I will now be able to move with that information.
Okay. All right. So at this point, that's really the main thing. So I think what I'd like to do is, your letters are good, let's see, until November 14. So I think what I'd like to do is just go ahead and set this to November 7.
Okay.
At 10 a.m. and just leave things where they're at, and have you go ahead and do what you need to do as far as another petition, if that's what you want to do. And similar to what I've said earlier in these hearings, there is an attorney that you can talk to Mondays starts at noon. It's first come, first serve. They run from noon to 2. And if you just need to ask some questions of what you need to do procedurally, they're the ones that you could come and talk to.
Okay.
Okay.
I have one more thing I was told to let you know on my court date was I got his state benefits transferred over to under me. And they did tell me that for September, which he was in my care all of September, and now for October, because of the notice they have to give her, she will be collecting his benefits.
So, so as far as, are you, what are the benefits?
So I believe she got food stamps for him and also TANF for him.
Okay.
Monthly.
So I don't want to give you legal advice. I can't give you legal advice. So you may want to talk to the attorneys, as I said, that are at the Hall of Justice on Mondays from noon to 2. Cowlitz with Kayakum Legal Aid is another place you can talk to somebody, or Northwest Justice Project. Those are all options of places that you may be able to talk to somebody and get some direction of what you should do.
Okay, perfect.
Okay.
Thank you.
All right. That concludes your hearing for today. I'll go ahead and set this over to November 7 at 10 a.m.
Thank you so much.
Thank you. All right, we still have Corinne Kell. Ms. Kell, which matter are you here on?
I was having Wi-Fi difficulties getting on. I know I was supposed to be on
What
at
case
10
are
o'clock.
you on?
Dayton Thompson spec and Chance Ingram spec.
Okay. So at this point, we already had the hearing and I set it over to November 7 at 10. Is that the date I set it to? Hold on, let me verify. I may have just given you the wrong date.
Okay. I'm sorry. I don't know what was wrong. I had to redo my wireless router and stuff. My Wi-Fi wasn't working, so I got on as soon as I could.
Okay, I apologize. October 24 at 10.
Okay, let me write that down real quick so I don't forget why I got you on here, because I am very bad.
Okay.
Times. Okay, you said the 24th?
Correct, October 24th at 10.
10 a.m. court. Okay.
Okay.
And it just got set over, that's it?
You're welcome to contact the clerk's office to get more information. I don't want to try to recall exactly what I did.
Okay, ma'am. Thank you.
All right, thank you. That
Bye.
concludes this docket.
We will go on the record in the matter 22 FA 45 in re the marriage of Timothy Ainley and Rachel Ainley. Appearances are we have both parties appearing in person without counsel. We're set here today in this matter for a contempt hearing. We were here previously on November 8th, 2024, in which we had a little bit of a hearing, and the parties were instructed to bring all evidence and information for the court to present here today. At the last hearing, Ms. Ainley informed the court that she was prepared to proceed with an accepted offer of the house for November 22nd for tomorrow to sell the house. And she needed Mr. Ainley to sign off on everything. And that's why the court scheduled the final hearing for today. Mr. Ainley, this is your contempt hearing, and so you have the burden of proof. I'm going to have both parties stand, raise your right hands, be sworn in.
I swear that the testimony you're about to provide to the court will be the truth, the whole truth, and nothing but the truth.
Yes.
I do.
All right, you may be seated. Mr. Ainley, at the previous hearing, you had indicated that there was a list of property that you stated that you had left at the marital residence, and that either was just left there and you had not yet received, or that Ms. Ainley had destroyed and that you wanted compensation for, and you were going to inform the court of that property and of the value that you were seeking. You may begin with your testimony.
Yes, ma'am. After the divorce was final, we came to an agreement that day on everything that was supposed to be surrendered to me. And she agreed on that. Well, being that there was a restraining order or no contact order in place, I had to come to court and get a court date set. It was signed by Commissioner Krupa for 2 days on a Friday and on a Saturday and Sunday to go retrieve my property. And the agreement was she was not to be on the property or on the property when she was supposed to have everything staged in the driveway with all my personal property. And I went out that day and some of the items were out in the driveway. And I pulled in and started getting stuff. Here she comes. She had her boyfriend or whatever, fiance, whatever, doesn't matter. But she was there. And I automatically just had an anxiety attack. So I just got what was in the driveway, left. And therefore I couldn't go back the next day because, I mean, she was there and that was, that was a violation. Really, I couldn't go back. She was there. And to my knowledge, she refused to let me go to the property while she is not there and not have access to anything that was in the home or my personal belongings or my four-wheelers and everything like that. And my pontoon, my chainsaw. I had I got a list here of stuff that was, and I did retrieve a few things, and what was there was damaged and beyond repair. I mean, it was destroyed. The hole drilled through the block of the four-wheeler, the lawnmower. I mean, everything I had was just what I got. We did retrieve that was in the driveway was totally destroyed.
So at the time of the divorce with Commissioner Krupa, and that was, well, actually, the divorce was with me on March 6th. There was a list of property that you were to retrieve. Is that correct?
Yes, ma'am. I'm not real sure of the exact date. Commissioner Krupa put that order into place. My attorney at the time was Adam Benson.
Oh, that was September 28th, 2023, in which you had the hearing with Commissioner Krupa to go retrieve your property from the divorce.
Yes, ma'am.
And it says, though, that anything not picked up after those 2 dates is considered abandoned.
Exactly. I could not go in there. She was there, and it stated in the order from Commissioner Krupa that she was not supposed to be there. She was, I mean, that was just a setup for me to go back to jail again for violating an order of protection.
At the hearing on September 28th, 2023, did you provide a list of that property to the commissioner or to the court of what you wanted to retrieve?
That list was already included with our divorce hearing. All of my personal tools, all of my personal property, the furniture in the basement.
Yes, that was exhibit 1, the personal property list. And yes, I have that. Okay. And we're talking about the pontoon, the tools, the generator, the Ford Ranger, the chainsaws, all personal belongings. That list, is that what you're referring to?
Yes, ma'am.
Okay. You may proceed.
I have a list here which doesn't scratch the surface, but I have a list here of everything that I have not retrieved and that was either damaged or not damaged, but destroyed. I never got anything back that was damaged other than the toolbox, the Performix toolbox, and that had sat out in the pontoon along with whatever else was in there for a couple winters, and it wasn't even salvageable, excuse me.
First, Ms. Hess, formerly known as Ms. Ainley. Were you at the property when Mr. Ainley went to retrieve his?
I was in the house, yes.
Why were you at the property?
I had nowhere to go and I had to get his stuff out.
You were specifically told at the hearing with Commissioner Krupa on September 28th, 2023, that you were not to be anywhere on that physical property.
I didn't have a choice.
You did have a choice because Commissioner Krupa said not to be on that physical property, not to be on that residence at all.
I didn't have no idea what time he was supposed to even be coming.
It
Was I supposed to
says,
stay gone all day?
you do,
I didn't
you
know.
did know, and I can tell you right now, you did know because it says pickup times, September 30th, 2023, between 2 PM and 4 PM, and October 1st, 2023, between 2 PM and 4 PM. So you knew exactly when he was gonna be there, exactly.
Leaving his stuff out there, he's
So-
already saying it was damaged.
You,
I don't
you
want.
just lied to the court. You just lied to
No,
the
I
court.
did not know.
You did know. You did know. That's
He didn't
physically,
show up. No, he did not show up when he was supposed to. There was time set in June for him to come. He didn't show. I didn't know if he was gonna show or not. I wasn't gonna take a chance of leaving his stuff sitting out there.
Mr. Ainley,
Your Honor, if it need be, I've got two witnesses that came with me with two trailers to load my personal property up. Her and her ex-fiance was out there. Her middle son Dylan was out there. They were all out there. She walked up and down the driveway following me, trying to talk to me. So that's all I gotta say. She was there. She knew the date. She knew the time. I was there about 10 minutes after I think it was I really can't recall the exact time on the
Mr. Ainley,
clock.
I believe she knew the date. I believe she knew the time. She just lied to the court.
Yes,
I do
ma'am.
not find her credible at all.
Yes, ma'am.
Continue.
All right, this is a list of my personal property. All my clothing, all my suits, my dress slacks, everything from hunting, winter, everything was burned in the backyard. It was told, my children told me that.
You can't tell me what your children have told you.
Journey, my 9-year-old, and my 12-year-old said that.
You can't tell me what they've told you.
Okay, so what are you asking then?
I'm asking what property you have not received and what you're asking as reimbursement for that property.
I don't have it added up, but I've got everything itemized with the replacement costs. It just have to be added up. I've got, this,
To know where you've come up with these prices.
well, for one thing, the Performance Toolbox, I bought that at Menards about probably 5 years ago 6 years ago when we bought the property. And I just looked up the replacement costs on it. No taxes included or nothing. And, I mean, this is the bare minimum cost it would cost to replace my equipment, my tools, my personal belongings, and I even went on the low end of what it would, actually cost.
Can
to
you hear
replace.
him? Is he mumbling? You need to speak in
Yes,
the
ma'am.
microphone and you need to speak clearly because the court reporter needs to take everything down. If I can't hear, that means she can't hear.
Yes, ma'am. I went through and researched everything that the replacement cost on every piece of equipment and all of the tools itemized of what it would cost to replace them. And I went on the low side of on the price that it would cost to replace my tools and my personal belongings. And, this is a bare minimum. I'm not asking for anything more other than so I can replace my equipment to get my contracting business back off the ground. And, I mean, without these tools, I walked out of that house when we divorced. I walked out of there with a torn up clothes basket with 2 pair of shorts, 3 pair of underwear, and a couple pair of socks. That's all I ever got out of the whole divorce. And it's just, and when I told my stuff was burned in the backyard, it's pretty kind of heartbreaking because I had really nice clothes and I dressed nice. I mean, everything from the Ranger truck. I got pictures of the Ranger truck that was destroyed, and supposedly my clothes that were supposed to be in the back of it that sat out there for a couple winters. Not one piece of clothing was in the back of that truck that belonged to me. There was one shoe, a pair of my Docker dress shoes, one shoe, and the rest of it looked like her clothes she's just thrown out in the back of my truck, and it sat out there. It was just molded and saturated. I could tell it sat out in the back of that abandoned truck for a long time.
You're telling me a lot of stuff that's not relevant and that you don't have personal knowledge of. I need to know what you know and how you have personal knowledge of it. And I need to see evidence and proof.
I have pictures of everything that was in the truck and the damage to the truck. I have the pictures of the truck and the stuff that she returned that was in the back of the truck when I had it towed to my house. I basically had a garbage dumpster towed to my place.
All right, so the court is taking judicial notice of Exhibit 1, which is document 36 in case number 22 FA45. That is the list of your personal property. And I'm guessing you're talking about your Ford Ranger. If you would like the court to have any exhibits, and if you're talking about those pictures of the truck and any list of items that you're asking the court to reimburse you for, which you still need to provide testimony as to those items and as to the amounts that you're seeking, I need them to be marked as evidence and provided not only to me, because I informed you I needed a copy, Ms. Ainley needed a copy, and you needed a copy, so you needed to provide 3 copies.
Okay, I wasn't clearly aware of that. That was my mistake. I do have a 1 copier. I can get copies made. If I could have a few minutes, I can take the staple out and take them down somewhere and have copies made of
Go
everything.
pay for copies at the clerk's office,
Yes, ma'am.
and you can pay for colored copies of your photos, but you need to have a copy for you, a copy for Ms. Hess Ainley, and a copy for me.
Yes, ma'am.
But before we take a break and adjourn, Ms. Ainley, what would you like to say?
All of his belongings that he did leave are at the house. I haven't touched anything.
But I
His
don't,
generator,
but
his,
here's the thing, again, I fully instructed both of you. And I'm gonna guess you don't have pictures or documentation of their condition.
no.
And
it's
so
the same
I'm
way
gonna
he
take
left it.
testimony from both of you, and so far I found you not credible. So we're going to briefly adjourn, and you can go get copies of all of those documents so that we can all have copies. And if you have other documents that you're going to want to use as exhibits, you're going to need to make sure that you make them right now. And if you have a copy of some document that you're going to need as an exhibit, you need to go get copies made as well, so that I have one, Mr. Ainley has one, and you have one. Because the court needs one and each party needs a copy, okay?
Yes, ma'am.
All right, then we are briefly adjourned. All right, back on the record, same appearances as previously noted. Mr. Ainley, you have now went and got copies of your exhibits, one for you, one for Ms. Ainley Hess, and one for the court. You may proceed with your testimony.
Yes, ma'am. The replacement costs and the list of personal items are all stapled together there. It goes from the tools and equipment. It goes, it's continued there. And I've got a sheet with the heading clothing and footwear. And I've got furniture in the basement that was ordered to me. And then the last sheet is my sporting equipment.
All right, well, you have to provide testimony so I can understand what it is that you're saying that you didn't receive, and then where you, what cost you're looking for and where you came up with this value.
Yes, ma'am. Starting on page 1 with tools and equipment. I had a Performax
You
3P.
have to, you don't have to go exactly line for line and tell me, but because I'm gonna guess there's like 1,000 items.
No, ma'am. This is the personal property that I had for my business, for my sporting, for my hunting, fishing, camping, my dress clothes, my everyday wear clothes, my winter clothes, my winter boots, all of anything and everything that I needed to live an everyday life was gone. Everything on this list, I never received this, except I did receive the pontoon boat. The 18-foot.
The pontoon boat, okay.
Yes, ma'am.
And what was the value of the pontoon boat?
About $4,500. That's what I paid for it about 6 years ago. It's nothing real fancy, but it was nice for the family.
So you received the pontoon boat, so you're not asking for pontoon boat back.
I sold the pontoon boat. It had holes drilled all in the pontoons and the motor was busted all up on it. So I sold that for $1,200.
Okay.
The 22-foot camping trailer.
With regards to your, let's start with your tools and your equipment.
Yes, ma'am.
Now, you have a lot of tools and equipment here. How do you know that all of these tools and equipment were at the property?
Because I left not one piece, I left the property with nothing but the clothes on my back, basically.
And where did you receive all of the values for these each individual pieces of tools?
I purchased them myself personally. I purchased every piece of equipment, every tool that's on this list.
And how did you arrive at the value that you're asking for?
It is replacement cost to go buy, purchase the same exact item that's on the list.
How did you arrive at that value?
Oh, I Googled it, looked it up online.
But where did you get the value? Google that just doesn't come up with.
Menards, you mean stores? Menards. I got some of it at Menards. I got some of it on just different sites that sell that product and that brand name product.
I don't see a total for your tools and equipment.
No, ma'am, I haven't totaled that up because I didn't really know exactly what I would be awarded, so I thought I would let the courts do that. Here it is. It's on the last page.
Let the courts do that?
No, ma'am. Let me rephrase that. I do have it done. It's on the last page.
So the total of all of the items that you're asking for is $8,800?
No, ma'am. That is just for my sporting equipment.
And where's the total of the tools and the equipment?
That is, I never totaled that up because I did not know exactly what I would be entitled to. I can add that up.
But I'm not going to take the time to add all of this up.
This is all new for me, Your Honor.
So clothing and footwear,
Yes, ma'am. Clothing and footwear's $45.50.
and where are you arriving at this number? Because it's just a guess and I don't have any idea. We're not talking about like guess, or we're not talking about Michael Kors, or we're not talking about, you know, some other high end type of clothing. I don't have anything identified, just shoes and boots, coats and jackets.
That was just a low ball idea of even just skimming the surface of the stuff I had. Some of the stuff I looked up, like Docker khaki casual or khaki dress slacks. I just looked up pairs and I thought, well, I had probably 5 or 6 pair of those. I just a rough estimate, you know.
I don't even have casual and dress pants. I don't even have 5 dress pants, 6 shirts. You even have to itemize when you donate to Goodwill
I
for
agree.
tax purposes, and I don't even have an itemization of that for this purpose.
I wasn't aware that I needed to itemize it.
You do, you're
I
in
mean, as
court.
far as clothing goes.
you have to be specific because I can't just say, okay, well, I'm gonna guess there's $500 worth of clothes or $4,550 worth of clothes that she destroyed. I need to have, it needs to be specific. It doesn't need to be down to, it was 6 pairs of Dockers that were in great condition, 4 pairs of Levi's, 7 Nike shoes and things like that. But I need to have an idea because even again, for tax purposes, you need to identify when you donate to Goodwill or you donate to Salvation Army or you donate to anything like that, you have to have a general idea of 7 sweaters, 6 pairs of shoes, 1 table.
I understand that now. I wouldn't even begin to even start to know how many pair of Dockers I had, and those are $65, $70 a pair. I know I had 5 or 6 pairs of those, and nice dress shirts, tie. I mean, I have no way to even begin to make an itemized list of my clothing. I mean, I had a huge closet full of clothing. I mean, it's not like I go through on a yearly basis and inventory my clothing. I know it's a mistake on my part, but
You understand that otherwise you're asking the court to speculate.
okay, I understand that now that you put it that way. Yes, ma'am.
Furniture in the basement. I have a Samsung TV, surround sound for a TV, a couch and a love seat, but I don't have exactly what type it is. A coffee table, end tables, an antique dresser, deer mount, walleye mount, antique reel collection, but there's no dollar amount on those 3.
I have no way of even valuing my deer mount. To me, it's priceless. My walleye mount, I don't know how to value that. And with the antique reel collection, I have no idea what, I mean, I'm not asking anything for the deer mount, the walleye mount, or the antique reel collection. I'm just adding that onto the list so it is known what I have got missing. I'm not looking for any reimbursement on that. If, it's like, that's just something that's priceless to me.
You're asking for them back if they're there.
Yes, ma'am.
The sporting equipment,
Sporting equipment, I had a brand new center point bow, crossbow with a case and accessory that was $900. I had a clam portable ice shack they're $650. I had another ice shack heater that was $119. I had a Jiffy gas ice auger that was $350. I had a Vexlar fish locator FL18, and that was $509. I had ice fishing rods, 3 of those. They were valued at I looked them up. They're $237 through Gander Mountain. Ice fishing tip ups. They were Beaver Dam tip ups. Those were. I had 3 of them. Those are the Beaver Dams. I looked them up online at Cabela's. They added up to $240 for 3 tip ups. Bowtech Tomcat compound bow. I put the price on there that she paid for it. Rachel paid for it years ago, probably 8-9 years ago. She bought that for me for a gift or something for my birthday or something like that at a pawn shop in Luck when they were open. I'm not looking for reimbursement for that really. I was making a list and just logged it all down. But then I got the Bowtech crossbow. I had a case and accessories for the bow. It was $100. I had Fluger fishing rod combo sets. I had 3 of those valued at $360. They were $120 a piece. Fishing tackle box and tackle. I put a real low price on that, $500, which, that was super low. I mean, I don't know what all I had in there. I had thousands of jigs and lures.
all right, so Ms. Hess, you have a copy of all of these items that he is requesting. Are all of these items at the home?
No,
Why not?
because he took some of them.
He's indicating he did not.
Like Ford Ranger,
Oh.
the ice auger he took, his fishing stuff. I don't want his stuff. I mean, he can, whatever he wants from the house, go get. Don't care. And the deer mount is mine. I mean, he can have it. Don't care.
All right.
I just want this over.
Now, Mr. Ainley, you're asking for the Ford Ranger. That's on the list, but isn't this the Ford Ranger you received?
It is. I took pictures of the clothing and stuff that was in it, and I took pictures of all the damage to it. That wasn't drivable either. I had to have it towed on a tow trailer from the Grantsburg property to the Webster property where I was living at the time.
Because the serpentine belt was broke.
All right, so what's wrong with it, Mr. Ainley?
It was just beat all the pieces. The belts were cut off of it. All of the decals, emblems were all busted off of it. Their dents beat inside of it. It was just filthy. It was full of mice, rats, and old wet clothes. I sold that for $1,000 to a guy that worked for me out of Frederick, who worked under me. And I sold it to him for $1,000. He cleaned it up and got it running.
So if you sold it, then you can't ask for reimbursement for it because you no
Okay.
longer have it.
That's fine. That's fine. I just wanted to show the court, the level of degrading appreciation, the degrading things that I've went through.
All right,
With
now
this.
what else are you asking for?
Okay, I'm also asking for reimbursement of all of the reinstatement fees that I've had to pay for the mortgage payments and legal fees. The property was really, really close to being foreclosed on. I mean, within days, and I wasn't aware of this. The mortgage is just in my name because Rachel couldn't have her name on anything. She had so many judgments against her. So it's just in my name. The mortgage is through Cross Country Mortgage. I've got a reinstatement amount here that is paid. It's $10,059.40. That is current, and you've got copies of this. Is the reinstatement amount.
What number am I looking at? What exhibit number?
Where are we at with exhibit numbers?
Which document?
It's the Cross Country Mortgage ones. Oh, I apologize. You didn't get these. I apologize. This wasn't in the stack. Actually, it was. It's the Cross Country Mortgage reinstatement.
All right, I see it now. It is exhibit 1 and it says $10,059.40.
Yes, ma'am.
That's the amount you're seeking?
Toward the end, yes, ma'am.
Is that the amount you paid?
That's the amount that was added on, and part of the amount that I paid, this is the amount I paid, yes, ma'am.
You'll get the chance. And you're saying that you paid this amount to keep it from going into foreclosure?
Not the total amount, no, ma'am. Part of it went on the back of the loan.
Okay, now explain.
I've got the paper for that too. I've got the total payoff on it. I have copies of the payoffs here, 3 copies. And with the legal fees that I had tacked on here, that's going on the loan that I don't feel that I should be responsible for because I pulled it out of foreclosure. And I've been making the payments for the last probably 7 or 8 months. I've got everything here.
Which are what?
I've got my bank statement payments where I've made the payments on,
Exhibit 5. Your bank statements. Yes, that's what you're asking for?
yes, ma'am. And then this is copies of the payoff. I mean, it shows, I've got 3 copies of this also. It's gonna be needed here in a few minutes.
Okay. You want to mark it?
Yes, ma'am.
Go ahead and mark it.
This is, okay, I'm gonna kind of jump back and forth just a little bit here on the reason I received this. I've received 5 letters in the mail from mortgage companies and lending companies stating what the payoff is, where they requested payoffs on the loan. And my loan and mortgage information was all sealed. No one had access to it at all because my ex-wife here tried to get in to find out a payoff on it about 6 months ago. And they told her, no, you can't. Tim's gonna have to get that for you. So anyways, I got 5 letters in the mail from 5 different loan companies and a title company stating that someone requested the payoff. So I got a letter from 5 different companies for people that requested the payoff, and they sent it to them. So I called them yesterday and find out why. And they said, well, you signed a release form on November the 5th of this month to release information for your payoff. I said, no, ma'am, I did not. And I said, ask her if she could email that to me. She said, yes. So she emailed it to me, and my name has been forged on this paper. It is not my signature. And the owner is not Rachel Ainley as far as the loan goes, what's on the loan mortgage papers. So she forged my name on this paper to get the payoffs on my personal information.
Who did? Ainley, please be quiet.
My ex-wife has signed my name multiple times when we were married. I give her permission to do that when we were married. Nobody else knows my social security number but her. She knows it by heart. And on the November the 5th this year, she signed my name for release of my personal information on my banking information. It's, I'm pretty upset about this. I mean, it's like a total breach of my confidentiality and everything else in my personal business. The lady called me yesterday from a title company. Let me get I'm just nervous. A lady called me yesterday from a title company. She said, Mr. Ainley, we have a check for dividends for the sale of your property on North Boston Road. I said, a check for what? She said, well, we're closing on that on the 23rd. I said, absolutely not. This is in legal issues right now. I said, no. I said, I'm not getting a check. So anyways, I told her my name was forged to get the payoff and the information on this mortgage. And so she didn't say anything else. She hung up. But in the meantime, I'm in the house. I've got a paper here from Leon from Grasswood Realty where she refused a $197,000 offer a few months back.
And that is exhibit number 3.
This is not my signature.
I don't have that in front of me. I don't know what you're referring to. This is not my signature. Are you going to have the court review that and look at that?
I gave copies to everyone.
Where is that? In what document? Oh, that is the first page of exhibit number 1.
Yes, ma'am. I apologize for that. I tried to keep it in order.
Oh, all right. Oh, and it has social security numbers on it that need to be redacted.
Yes.
Where it's signed. And it looks like Timothy Ainley on 11/5/24, and then it's Rachel Ainley on 11/5/24 with social security numbers. That is not your signature.
No, ma'am.
You did not sign that authorization to obtain information?
Absolutely not. This was signed 3 days before we had our court hearing on the 8th of this month when you postponed the court date to today.
I'm going to tell you that I'm looking at the dates and the social security numbers as they are written, and they look exactly like they're written by Miss Ainley. The dates and the social security numbers as written, the 8s are identical. I'm not a handwriting expert, not one who has went to school, but I'm gonna tell you, just by looking at it, Miss Ainley, I'm gonna tell you, you did this.
No, ma'am.
Oh, yes, ma'am.
Where would I have signed it? I haven't been anywhere to sign anything.
Your name is signed on this.
I'm not
These
Rachel
dates are
Ainley.
stop talking over me. You did this, Miss Ainley. You signed this, Miss
I
Ainley. You signed this.
No, I
You
didn't.
did this.
No, ma'am. I promise you I didn't.
Oh, you can promise all you want. You are not credible.
okay,
You did this.
okay.
These 8s are the same. This 11/5/24 dates are the same.
They're not though.
They're the same.
You can call Katie. I'm not the one that signed.
I can call Katie?
Yes, ma'am. I did not sign.
You didn't sign in front of Katie.
I didn't sign at all.
Oh, so somebody forged your name
Ma'am,
too?
I have not signed anything. I was supposed to sign with the title company on Wednesday and I didn't.
Oh, so I have 2 fraudulent transactions here. Somebody forged your name, your
Yes, ma'am.
social security number and yours. That's good. I need to let the district attorney know right now. We have 2 fraudulent transactions done. Not only do we have it for you, Mr. Ainley, but we have it for Mrs. Ainley too.
I mean, you could check signatures even. I don't sign like
I
that.
don't believe that at all.
Okay, that's whatever. It is whatever. Not next day's gonna change it.
If I wouldn't have gotten these letters from these loan companies, from my mortgage company stating that these 5 lenders requested my payoff information, I would have never known that there was any type of fraudulent activity going on at all.
This is not fraudulent.
I'm looking at 22 CV 88 Rachel Ainley versus Timothy Ainley, your injunction request that you filled out. The signatures look almost identical.
Almost.
Almost identical.
They're not me, I promise. Forging signatures, risking getting felonies when, no, not worth it. I'd walk away from the house before I do that. Not stupid.
Almost identical. The signature Rachel Ainley on 22 CV 87, 22 CV 88, Rachel Ainley signature, almost identical.
Almost. It's not me.
You can't sign your name the exact same every way. I don't sign my name the exact same every way, Miss Ainley.
I didn't say that. But it wasn't me. I'm not an Ainley. I wouldn't sign Ainley.
It says Rachel Ainley. Because
Exactly.
you want to know what? Rachel Ainley owns the house, not Rachel Hess. So you have to sign it Rachel Ainley.
See, I don't know. I didn't know that.
Please continue.
You know, I just, I have, what bank statements I could acquire from all of the payments I made and the electric bills I've had to pay, to keep turn the electrics back on at the house there. I even paid their cell phone bill, so my children have their, well, my older daughter have her phone. My 2 younger ones don't have a phone yet. I don't know how that, but, I just have statements here, bank statements of what I paid out and what come out of my account with my debit cards or whatever I paid with. I've got a 3,564.71. That's all the statements on the house payments that I made. And some of them are for $660. That's because that was the $660 was the previous payment amount on our mortgage. And when I got it modified to pull it out of foreclosure twice, the payments went down to I believe it's 564 something, I believe. Anyways, now that it's remodified, I sent off a loan modification contract yesterday morning through FedEx. We signed them to keep the house afloat, keep from losing it. I'm still continuing to make the payments on the property. If not, I would lose everything, my whole life savings. Anytime my ex-wife has gotten any large amount or large sum of money, it's never spent on what it's supposed to. Bills, kids' bills first. Like I said, about 5 years ago, we were involved in a serious accident, her and I, in Hayward. She got a $40-something thousand settlement, never paid him payment on the house. And then, like I said, I got in some legal trouble back in May. And I was incarcerated in Polk County for a couple months. So I was totally ghosted out of everything. And when I was released and went into a sober living home, I started getting mail after I had my forwarding address to my home now. And I found out that it was going into foreclosure, and I caught it within like 4 or 5 days before it actually was foreclosed on. So I've done everything in my means. I can't do it anymore. I mean, you know, I can't keep paying $1,085 a month child support, a mortgage payment. Plus we have to pay $600 a month at Onyx Sober Living Place. It's an awesome Christian living home. I have to pay $600 a month there on top of gas and food. And I'm trying to get steady work, and it's like, which this is coming through good too. But anyways, I just can't do it anymore financially. I mean, if it wasn't for God keeping me strong in my mind, I don't know. I would have lost it even worse than what I did back the last year and a half over this divorce. All I want is what I believe I deserve and what I have invested in the material things that's there now on the property and the home. And that's not even counting the things I've lost over the 17 years being married to her.
All right, Mr. Ainley, so I can understand it, and then I'm going to ask Miss Ainley Hess if she has questions for you. As I can understand it from your testimony, if I can find that list. I added up all of the tools and equipment, and it comes to around 23,000, give some odd $100 with the tools and equipment. And then 45 or $4,550 for clothing. But again, as I went over their speculation, $5,450 for furniture, $8,803 for sporting and equipment. But again, you understand, I'm not saying that I'm going to award you all of that or any of that, quite honestly, because there's speculation, and I have to consider testimony and listen to the argument and evidence from Ms. Ainley. But that's what you're asking, and you're having the court consider, correct?
With the reimbursement of the payments.
I'm not there yet.
Yeah. Oh,
with
yes,
that.
ma'am. Yes, ma'am. Yes.
And then with regards to the home, you're asking for the court to reimburse you for the payments that you've made to keep the house out of foreclosure, which would include, as I have in Exhibit 5, and you've highlighted, a total of $3,564.71 for house payments, and for, I believe it's for house insurance, and you're asking for cell phone bills and electric bills for those reimbursement payments, and you're asking for the court to reimburse you from Exhibit number 4 for an additional house payment of $554.46. And you're asking the court to reimburse you for $10,059.40 as shown in Exhibit 1. And I don't know what you're asking the court to do, perhaps punitive damage, or to look at credibility issues or fraudulent issues as it relates to a forging or a allegation of forgery of your name of Miss Ainley with the Exhibit 1 with the authorization to obtain information that I have here. Is that all correct?
Yes, ma'am.
Am I missing anything?
As far as everything that I'm asking for to be rewarded to me,
Yes.
on top of the $27,000 that I was originally supposed to, okay.
Thank you. And
Yes,
that's,
ma'am.
I forgot about that. On top of the $27,000 from the findings of fact, conclusions of law from paragraph number 9, it's actually $26,000 in equity.
Yes, ma'am.
So it's $26,000 in equity. That it says Mr. Ainley is awarded $26,000 in equity and equalization of the parties' overall property division. All right. In addition to that, now, what were you asking of the court with regards to Exhibit 6 in this? Was this just an exhibit to show the court what is remaining on the mortgage?
Yes, ma'am. That was the request for a payoff.
Okay,
from
just
other-
showing me what is
And
left
I
to
have
pay off.
5 of those, so I gave everybody one for the proof of the payoff that's current.
All right. Okay, Miss Ainley, do you have, this is not your time for testimony. You will get time to testify and to provide your own evidence for the court. This is your time to provide or to ask questions of Mr. Ainley as it relates to his evidence and his testimony to the court. Do you have questions for Mr. Ainley?
Yes, I do.
You may begin.
When did you purchase this stuff? Cause, a lot of it, you never had when we were married.
And I'm going to state for the record by stuff, you're referring to what he has listed in.
Oh, yeah,
his-
like a DeWalt cordless drill combo. $900? Really? Where'd this come from?
I purchased that one.
I've got plenty of witnesses.
Should have brought them with you.
Oh, I should have.
I purchased those, that DeWalt cordless skill saw drill, hammer drill set with a sawzall in it. I purchased that in Nashville, Tennessee when we moved down there when I started my remodeling business. We owned property down there at the time also. I believe I purchased that at a Lowe's building center. To my knowledge, yes.
Am I okay to talk now?
Next question.
Okay, your Husqvarna is your turn. How'd you get on the trailer?
It started
You
up-
drove it.
Well, let me answer. It started up for a minute, and oil blew off the side of it, and then we had to take a come-along winch and winch it up on the trailer to get it on the trailer.
And your four-wheeler?
Same with the
Nothing was wrong
four-wheeler.
with
The
it.
motor was busted out of the four-wheeler. It would not run. We had to push that up on the trailer.
No,
Well, I thought you weren't out there when the stuff was
It is
loaded.
not for comments.
it was on my property.
And it's not for comments or for testimony. It's for questions of Mr. Ainley.
Yes, ma'am. The four-wheeler is totally destroyed. It was not runnable. It would have cost more to repair it than to purchase another one.
Okay, and then where did you get the price for the furniture in the basement? Because that stuff came from a thrift store, not $3,500.
No, ma'am, the furniture did not come from a thrift store.
Yes, ma'am, or yes, it
It
is.
was. Asked to answer. I'll wait, excuse me, I apologize. I'll wait till I ask and answer that question. The furniture was brand new. I went and done voluntary work for a gentleman over in, I believe it was outside of Siren. I helped him cut wood, and the man traded me my labor because we were doing voluntary wood work, cutting and splitting wood, and I was helping him deliver some stuff. It was all community service work, and I was volunteering my time. And I helped him load and move some furniture into a storage unit. And I said, I believe the guy's name was Dan. I don't remember. It's been so many years. It's been probably 8-9 years ago. But anyways, I said, oh, that's a nice love seat and couch and ottoman and chair. I said, that's beautiful. It looked good down in the basement that I just remodeled. He said, well, I tell you what, load it up, you can have it. So the price on that furniture, the furniture was brand new, it wasn't even used. I mean, it doesn't matter whether I paid for it or not. It was mine and it was awarded to me. And if I wanted to go buy another set just like it, I couldn't even really, I looked stuff up online, like at some of the furniture stores, and that was the closest range I could come to. And that was the lowest, one of the lower, low end prices on something that was even similar to it.
Next question.
I have nothing more to say. It's just, I don't even know what to say.
All right, now, if you don't have any other questions for Mr. Ainley, this is your opportunity to provide your own testimony to the court and your own evidence to the court as it relates to this matter. You've heard Mr. Ainley provide his evidence and his testimony to the court, so this is your time to provide any contrary evidence or contrary testimony to the court. You may
Do
begin.
you want a copy of what Commissioner said on the 10th of October?
I will have it in my file if that's what you're asking. I can take judicial notice of that. Let me get to.
Because that has what his lawyer added up on what I have to give him.
And what date is that?
It was on October 10th.
Of 2023?
24.
October 10th of 2024. All right, I have that order right here. It is actually signed October 14th, 2024, and I have that right here. Yes, it says that Ms. Hess has paid Mr. Ainley $5,000 of the $26,000. Therefore, she still owes $21,000 out of that $26,000. Yes, Ms. Ainley, you may continue with your testimony.
And then I have from the buyers of the property. They had tried messaging Tim about fine, and Tim told them that the only way that he would sign in and cooperate is if I agree to give him 55,000. Ma'am, I'm not asking for all of the money, but I am gonna need enough to get me and my kids a place. And I with everything I've given him, I even his ice auger, it's not my fault if he sells it.
Ms. Ainley, I'm not hearing anything to contradict anything that Mr. Ainley has told me with regards to the property.
His property is there. Everything he left. Nobody has touched it.
I don't believe you. I don't believe you.
You could send somebody there.
I
It's there.
see pictures.
That was stuff that was put in his truck while he was there. That is not what I sent for him.
I can always do an order that he can go and retrieve property and with a dollar amount order. And if he retrieves property and it's not damaged, then that property, it diminishes the dollar amount that he gets. But I don't have any contradictory evidence. I don't know
what I can give you.
Ms. Ainley, I told you exactly what to give me on November 8th. I said, I need pictures, I need testimony, I need things. And what you needed to do then was you knew what he would be looking for. You knew what property was his or what he would be seeking.
And it's still his.
So you knew though, you have a cell phone, you have a camera, pictures. You could have brought pictures and said, look, judge, not damaged, still working. That's exactly what I told you to do. I told both of you I needed evidence. You needed to come here prepared. This was your day. This was it. This was the one and only day both of you would get. I was very clear with both of you, correct?
Yes, ma'am.
Very clear with both of you. This was your day to come prepared. Very clear. Without going out myself and taking the pictures and doing the case myself, I was very clear at what both of you needed to do. And you didn't come prepared to do that. Except you're coming and you're saying, it's all there, it's fine. But I'm hearing testimony that's saying it's not fine. I'm seeing pictures where it's not fine. And quite honestly, Miss Ainley, I hear testimony and I see things that show you're not credible. I believe you're not credible.
Okay.
I fully believe you forged his name.
No, ma'am.
I fully believe you forged
And
his
how
name.
would I do it?
Hi, pen, hi, paper. Let's write Tim Ainley.
No.
I'm not blind. I can see.
Well,
And
maybe
I've
we should have
taken
someone look at it then.
judicial notice. I've been doing this job a long time. I look at your signature on 2 documents where
Yes.
you've signed.
Look at his.
I have. It's
I
not
don't-
his
It's
signature.
not mine.
This is your signature,
No.
Rachel Ainley.
Can you call Katie? I didn't sign.
Then you were not looking to sell this property because this is what it took to sell the
I
property.
can't sign. You told me we couldn't sign
Sign what?
the papers yet.
You didn't sign the papers. This was to try and get a payoff, to try and get the offer.
I've made
what
no
you
attempt to
got.
get payoff. They do. The company does. I make no attempt. I have not made any attempts.
Need payoff, please.
It's sincerely Katie, not Rachel. And Katie is wherever that is.
Miss Ainley, the more you talk, the more you're digging your hole.
Okay, well, I'm not gonna say anything. I'm telling you.
I strongly encourage you not to, because this is all taken down.
Okay.
And this is a transcript, and the district attorney can get this transcript.
Okay, that's fine. Because I don't have anything to hide. I don't. I would have plenty of witnesses, but you didn't want kids here.
I said, bring witnesses.
I wouldn't put my kids through it.
And I think that that is the best thing that you could do
That's who I had.
as a mother. Because quite honestly, that was a terrible,
It was.
awful thing that happened at that other
So by
hearing.
not bringing them, I have no credibility. So just order what you're gonna, order what you're gonna. I just want it done. I want,
If either of you put your children in the middle, you are awful parents.
that's why they're not here. That's why I have no witnesses. Because all I had was my kids.
No, you don't. Miss Ainley?
Yes, it was. It was.
You can stop crying because tears,
I'm not crying because of that.
again,
You're
telephone.
not listening.
You're not listening. Stop crying. Stop that. Telephone pictures say 1,000 words. Stop it. This
order
boo-hoo,
what you're gonna-
cry means nothing.
Okay.
See? No tears. Nothing.
Oh, I got none now.
I know, because they're not real.
Oh, yeah.
I don't
Okay.
fall for those
Okay.
tears. So now, do you have any proof or any evidence? Because quite honestly, right now, there's nothing in your favor.
I guess not.
Because I fully believe, Mr. Ainley, I truly do believe you walked out with nothing. I believe you walked out, quite honestly, with the clothes on your back. And with what you said, you had a couple shirts, a couple pair of underwear, a couple pair of socks. You had nothing. I can't tell though, Mr. Ainley, if all of this is accurate and true. I can't. The problem is that at the date of divorce, I'm gonna tell you, the date of divorce that I handled, it was a contested divorce and you had an attorney. Even when you had an attorney, quite honestly, gonna be blunt, you were quite, not so smart. You've never been smart with this lady. You've never been smart with this lady.
I agree.
You've let her control you and take everything from you. Because when you are here and you came here with your divorce, you came with this exhibit of personal property that you wanted to retrieve, and it's bare bones. It's not really that enforceable. You should have went that day or very soon after that day to retrieve this personal property. And then when you went back with your attorney in front of commissioner to retrieve your property, and it's very clear in that hearing that commissioner said 2 dates and 2 sets of times to go retrieve your personal property, which Miss Ainley said today, I didn't know, which was a lie, because she knew, because it's very clearly there in the minutes.
Ma'am, I said it wrong. I didn't know he would show up because he was set to come before and he didn't show. He was set to come in June and didn't show up.
Well, he had his attorney, he paid his attorney, they went to a contempt hearing, they got 2 specific dates with 2 very specific times to go show up. And you were instructed not to be on that property, not to be on that residence from 2 to 4 p.m. on September 30th and 2 to 4 p.m. on October 1st. Very 2 specific times, 2 hours
Yeah, I'm
on
guilty
2
of it then.
days.
I'm sorry.
Stop talking. 2 hours on 2 days where you could have just went to Dairy Queen. You could have went to the dairy. You could have went driving. You could have went anywhere for 2 hours, those 2 days, and you didn't.
Agree.
So Mr. Ainley, you had these 2 specific times to go get this property and you went and she was there and it set your mind aside or you lost all track of what you were doing. But you needed to get your property that day because that's when commissioner said, get your property. And you didn't pick anything up that day. And then from September 28th, 2023, when you were supposed to get your property, even though you were supposed to get your property that day, she was not supposed to be there. Both of you didn't do what you were told to do from the commissioner. Neither of you did what you were supposed to do. Neither of you do what you're supposed to do. It's a history with both of you. Neither of you do what you're supposed to do. Neither of you listen to anyone. Now, going back to the personal property, it's very vague. I don't have this specific list of property from the date of divorce. You should have went back. You should have gotten it a whole lot sooner from the date of divorce because the date of divorce was way back. March 6, 2023, and it's now November 21st, 2024. There's absolutely no guarantee that anything is there and anything is in its proper order or condition. And I can't guarantee that any of these tools are the tools that you're asking for, because in your date of divorce, you said tools. And you didn't say Hilti hammer jack drill, DeWalt cordless combo set. You know, you didn't specifically identify. This is what you're supposed to do in a divorce. You're not supposed to list tools. In a divorce where you get along and it's amicable or somewhat amicable, you can list tools. In a divorce with gasoline and fire, like this, gasoline and fire, you list everything out exactly what it is, word for word, item for item, value for value, not tools. Because it makes it very hard when we're here in November 21st, 2024, when this divorce was March of 2023, and I can't go back and say, okay, now what tools did you really have during the marriage? You understand?
Yes, ma'am.
I wish I could, because I do find you more credible, Mr. Ainley. Although in this divorce, it's hard to find credibility.
Can I add something, Your Honor?
No.
Okay.
And it's hard to find, you sold the pontoon, that's taken care of. The tools, it's hard to find. There's a generator, the Ford Ranger, you sold that. There's chainsaws ×3. It's very hard to determine the value of the property that you listed at the date of divorce. And that's what I have to go off of. I can't go off of what you identified here today.
The day of the divorce, my attorney, Adam Benson,
I can't
asked,
hear what your attorney
I said-
said or told you. I can't hear that. And it's not that I can't hear you because you're soft spoken right now. It's because what happened at your date of divorce happened at your date of divorce. That's the past. It should have happened at the date of divorce. So lesson learned. Next time you get divorced, if it's gasoline and fire, you make sure that you have a list identifying each and every item. Because otherwise, if you say tools, you might get a screwdriver and a hammer. You are entitled to have some of your property, and I can identify some items here because some do correlate from this list, this personal property list from the date of divorce to the list that you have provided here, such as the generator, and you do have the chainsaws. You have all personal belongings, and I guess I can equate that to some of your clothing. And you have the furniture in the basement and the TV in the basement. I don't know if you listed the small trailer. But all in all, in looking at what you're asking for today, when you go through a divorce, at the time of divorce, the judge says, you understand that after today, you can't come back and say, you know what, judge, I forgot to ask for something, because that date is done. You only get what you ask for at the date of divorce. And those are what's listed in Exhibit 1. And if I'm calculating correctly in Exhibit 1 minus what you've already received, I'm having an issue with the clothing because I can't decipher if you've had how many shoes and boots and coats and jackets and all of those things you've had. I do know that they are clothing is worth a lot. Ms. Ainley, do you have an idea of how much clothing in a dollar amount he would be entitled to? You have an
I had
amount?
no idea his sucking got burnt, man.
Do you have an idea of how much you would stipulate to?
I don't.
Well, in looking at Commissioner's order, I see that you are entitled to $21,000 still from the original order from the findings of fact. The court is going to order $3,564.71 from the house payments, from reimbursement for the house payments, the house insurance, and the other bills. From Commissioner's order, there is also $5,008.14 for the 9 mortgage payments. $554.46 in the additional payment. $554.46 in that additional payment from Exhibit 4. And in my calculation, with all of the personal property that I can see in Exhibit 1, document 36 from the original divorce as compared to what is requested for today in the itemized list of items, I am seeing $18,200 for a total of $48,309.31. Plus, there is an additional $10,059.40 reinstatement fee. That the court is awarding. And I'm awarding $15,000 because I do believe that is a penalty. Because I do fully believe that Ms. Amy fraudulently signed his name. So there is a total of $64,368.71.
64,000 what?
$64,368.71. That is to be paid to Mr. Ainley from the proceeds of the sale of the home. If the home is not to be sold, if it's not sold tomorrow as expected, then the court is going to order that the home is going to be remitted over to Mr. Ainley for ownership instead of Miss Ainley.
Your Honor, the latest to close was December 30th.
Thought it was gonna close tomorrow.
We were supposed to, but he refused.
Well, then it can close.
If they're willing now.
If not, then I'm ordering that, if it doesn't close, then, ownership of the home, turns
Then
over to
How do
Mr.
I
Ainley.
get? How is that fair to me and the kids?
How is it fair? Because I fully believe you signed
I
his
did
name.
not.
I
What do I
fully
have to do to
believe,
prove it?
Ms. Ainley, I fully believe that you have destroyed his property.
I
that
did
you
not.
have burned his property, that you have sold his property, that you have thrown away his property, that you have done everything to keep him from having his property, that I believe that you have done everything.
Well, if somebody goes to the house, you'll see it's
And
not
you have
true.
been totally
Okay,
vengeful.
Well,
Now.
so you think, yep.
He can go and retrieve his property, and if all, Mr. Ainley, you have the ability to go to the property. You're still at the property, Miss Ainley?
I won't be.
When? You're out of the property? You moved out of the property?
I will be tomorrow.
You've moved out of the property
I
tomorrow?
won't stay there.
So are you moving out of the
Yes,
property?
I am.
And you're living somewhere else?
I'm going to, yes.
Okay.
I don't have a choice.
All right, so you can go to the property tomorrow and retrieve all of your property.
Time.
You can look all day. She's not gonna be there anymore.
What
And
if it's
apparently the
locked?
house is going to be sold.
What if it's locked up?
Well, you would have the ability to, you would have the ability to have a locksmith come and, go into the property.
Your Honor, what if he takes more than what's his?
He is ordered to only take his property, and that would be anything that is on the list that you have. He is not to remove anything else but anything on that list.
I will make sure I have a witness with me and take pictures, ma'am.
All right, so you can go tomorrow and, you have all day if you want.
One more question, Your Honor. The amount that I was awarded, the $64,368.71, if she closes on that property, is that mortgage company that's buying the house or whatever, they have to cut me a check for that
Yes,
amount
they do.
before I can
Yes,
close on
they
it?
have to cut you a check for that amount.
Yes, ma'am.
And so, Miss Ainley, it's not going to close tomorrow now?
I have no idea.
Well, if it doesn't close, then again, the court is awarding the home to Mr. Ainley.
As of tomorrow, I have one day.
It was supposed to close tomorrow. That is why
Yes,
this
but
court.
he refused. He told them no.
But here's the thing.
But
the-
that's why they went to December.
Miss Ainley, and the court specifically held this hearing today.
I
So
know.
it can close
I know.
tomorrow.
I know.
Did you not recall that I had a
Yes, ma'am.
mandatory
Yes.
education course that I had to have today?
Yes, but I don't have control over them. I don't.
You had it set to close
Yes.
today.
I had it set to close tomorrow.
If it closes tomorrow, Your Honor, I'll sign whatever needs to sign. That's not,
Yes,
that's not gonna slow up any
You
closing.
can contact them and the court will prepare an order here today and I will have it done here shortly.
Yes, ma'am.
And then it can be signed and Mr. Ainley, you can come and retrieve it by 4:30 PM and you can make sure that the company has it.
Yes, ma'am.
All right?
Yes.
All right, thank you. Then we are adjourned.
Thank you.
Is there any copies of papers?
What?